Alright. Dito tayo ngayon sa last discussion or last part ng discussion natin for credit transactions. Previously na pag-usapan natin si loan, deposit, guarantee. Ngayon, dito tayo sa last portion natin. Pag-usapan natin si pledge, mortgage, yung dalawang types of mortgage, si real and si chattel, and yung Antichresis. So, last discussion natin for credit transactions. Let's go! So, dito tayo sa Title 16, Pledge, Mortgage, and Antichresis. So, Chapter 1, pag-uusapan natin provisions common to pledge and mortgage. Yeah? Article 2085, the following requisites are essential to the contracts of pledge and mortgage. First, they be constituted to secure the fulfillment of a principal obligation. Second, that the pledger or mortgager be the absolute owner of the thing pledge or mortgage. The third is that the person constituting the pledge or mortgage have the free disposal of their property, and in the absence thereof, that they be legally authorized for the purpose. So, third persons who are not parties to the principal obligation may secure the latter by pledging or mortgaging their own property. And in connection with this, the provisions of 2086 tayo, the provisions of Article 2052 are applicable to pledge or mortgage. And 2087, it is also the essence of these contracts that when the principal obligation becomes due, the things which the pledge or mortgage consists may be alienated for the payment to the creditor. So, ano bang definition ng pledge natin? Ito yung una natin pag-usapan, si pledge muna. As we know, si pledge is a contract by virtue which the debtor delivers to the creditor or to a third person a movable, take note, movable or document evidencing incorporeal rights. Ano meaning yan? For example, hindi lang tangible ang pwede mong movable tangible, ang pwede mong gawing object ng pledge, but also accounts receivable. O di ba? Balikan nyo, financing accounts receivable. Ba? Financing accounts receivable. Kung saan mangungutang ka, in exchange for that, pwede mo gawing pledge yung accounts receivable mo. Di ba? Incorporeal right yan. Your right to receive payment on that particular transaction. Accounts receivable. Di ba? For what purpose? For securing the fulfillment of a principal obligation with the understanding that when the obligation is fulfilled, the thing delivered shall be returned with all its fruits and accessions. So, yan yung purpose ng pledge, di ba? Accessory obligation siya. There's a principal obligation. And pledge being a security, itatransfer mo yung movable or yung document evidencing incorporeal right, for example, accounts receivable, in that case, you are securing the principal obligation. Na kung saan, pag nabayaran na ang principal obligation, may babalik sa'yo yung pledge mo. Kasi sa pledge, may transfer nangyari dyan eh. Real contract kasi yan siya eh. Di ba? So, what is the cost or consideration in a pledge? As we know, di ba? Contracts, COC, essential requisites niya. So, ito, ano yung cost niya? Pledge is an accessory contract, as we know. So, kailangan niya ng principal. Its cost insofar as the pledger is concerned, diba? The pledger, yung magbibigay o yung magta-transfer ng property, whether that's immovable or document evidencing incorporeal rights, is concerned sa principal obligation siya, concerned. But if he's not a debtor, as stated in Article 2085, Paragraph 2, take note, ano yun? Third persons who are not parties to the principal obligation may secure that principal obligation by what? By pledging or mortgaging their own property. Pwede yan, kapatid. Pwede. Di ba? May si debtor-creditor, di ba? Tapos kaibigan mo si debtor, gusto mo matulungan, makabayad, so pledge mo. Di ba? Pledge mo yung motor mo. So, transfer mo yan kay creditor. Third person ka, labas ka dyan sa principal obligation. But, since kaibigan mo si debtor, gusto mong matulungan, okay, pledge mo yung motor mo. O, yun, pwede yun. Yeah? You can pledge your own property. Yan yung sinasabi dito. But if it's not a debtor, like yung third person, the cost is the compensation stipulated for the pledge or the mere liberality. Liberality, gratuitous of the pledger. As an accessory contract, its validity would depend on the validity of the principal obligation secured by it. So, di ba, accessory follows the principal. If the principal is void, the accessory is void. So, kinds of pledges, meron tayong dalawa, voluntary or the conventional, di ba? Alam nyo na, paulit-ulit yung narinig to si voluntary conventional, di ba? Stipulation of the parties to agreement nila, and yung legal is the one created by operation of law. And characteristics of a contract of pledge are the following. Familiar na kayo, real contract because kailangan ng delivery dyan. Perfected by the delivery of the thing that is pledged. Yeah? Second is the accessory contract. Wala siyang independent existent, nakadepende sa principal obligation. Third is the unilateral contract because it creates an obligation solely on the part of the creditor. On what? To return the thing. Yeah, to return the thing subject thereof upon the fulfillment of the principal obligations. Once nagkaroon na ng pledge, diba? So, na-transfer na yung property. Diba? Na-deliver na yung property kay creditor, being the pledgee. Or na-deliver na kay pledgee. So, in that case, there's a unilateral obligation on the pledgee, yung naka-receive ng property, para isauli yan, i-return yan once the principal obligation is extinguished, na fulfill na. Yeah? Kaya unilateral. And lastly, it is a subsidiary contract. Why? Because the obligation incurred does not arise until the fulfillment of the obligation which is secured. So, those are the characteristics of a contract of pledge. Ba? So, essential requirements of pledge and mortgage. So, sa binigay yan, sa Article 2085 and 27, diba? Ito sila. Ano yung mga essential? Ano yung mga essential requisites that is common to pledge and mortgage? Yeah? The first is that constituted to secure fulfillment of a principal obligation kasi nga, pledge is security, it is an accessory obligation. So, nandiyan yan siya, yeah? Para ma-secure yung isang principal obligation. Na kung hindi mabayaran yung principal obligation, then yung thing that was pledged or the thing that was mortgage, doon kukunin yung pambayad. And paano kukunin yung pambayad? May proseso tayong pina-follow as provided by the law. The second one is the pledger or mortgagor is the absolute owner. Kasi if not, di ba? Kasi if not, the pledge or mortgage will be void. Magiging void yan. Oo, pag hindi yan napawalo, yeah, magiging void yan. Kaya yung future property cannot be pledged or mortgaged. But it is not necessary naman that the principal debtor should always be the pledger or mortgagor. Diba sabi natin kanina, diba 2086 paragraph 2, kahit yung mga third persons, diba, na walang interest sa contract na yan, pwede nilang i-pledge, pwede nilang i-mortgage yung kanilang personal, yung kanilang property as long as pwede yun. Na? Kaibigan si debtor, gusto yung matulungan, etc. etc. Kaya basta yung pledger, not necessarily debtor pledger, kasi pwede third person maging pledger, pwede nilang yan. Pwede nilang ma-secure yan. The third one is the pledger or mortgagor has free disposal or has legal authority. Because the act of pledging or mortgaging is an act of ownership. Yeah? Is it an act of ownership that involves alienation? Yeah? Ano meaning ng alienation? Meaning, you can transfer the property without any restriction. Yan yung sinasabi na can be alienated. Diba? You can transfer, you can sell without any restriction. So, ganyan-ganyan. Predispose of the property or as legal authority. Kung hindi man ikaw yan, as long as you have the authority to do so. And lastly, the thing pledge or mortgage may be alienated. As you have said, kailangan ng transfer dyan. In addition to the above requirements, a thing pledge must be delivered or to the creditor or a third person to an agreement. Without delivery, there is no pledge. So take note, pwede mong yung thing pledge, pwede kay creditor ibigay, i-transfer, or kay third person. Walang problema. As long as both of the parties or the parties have consented to it. Diba? They agreed to it. Walang problema. Without delivery, there's no pledge kasi obviously, pledge is a real contract. Ngayon, pinag-usapan natin si pledge and mortgage or real mortgage. What are the distinction? Or anong pagkakaiba ng dalawang yan? Yeah? Thing pledge, di ba? Pledge constitutes on movables. While mortgage, particular real mortgage, pinag-usapan dito, immovables. So, mga land, building. Kasi, bakit? Kasi tingnan mo dito sa pangalawang distinction nila. In pledge, the property delivered is delivered to the pledgee or by common consent to a third person, while mortgage, sa third pala yun. Hindi. Pledge can pledge without the mortgage. Okay. Sa mortgage, delivery, not necessary. Yeah? Kasi nga, immovable yan, kapatid. Land yan, building yan, mahirap naman. Diba? Hindi na may madideliver, kaya nga tawag yan, immovable. Diba? Yan yung difference sila. Ting pledge, kailangan talaga may delivery. Sa mortgage, delivery, not necessary because of the nature of the immovable object. Diba? Kaya nga immovable. Third one, pledge is not valid against third person unless a description of the thing pledge and the date of the pledge appears in a public instrument. We'll discuss that later on. Yeah? Kahit, basically sinasabi yan, pledge, kahit hindi sa public instrument, valid against the parties. Gusto mo madama yung yung public, or gusto mo maging madama yung third persons? Okay, public instrument mo. While mortgage is not valid against third person if not registered. Diba? Sa registry of natin yan. And lastly, the pledger can sell the thing pledge with the consent of the pledgee. Walang problema dyan. While the mortgager can sell the property mortgage even without the consent of the mortgagee. So, for definition, see comments on mortgage, see comments on 21-24. So, yan difference sila. Pledger, kailangan ng consent. Mortgage, no need. No need consent. So, 28A tayo. The creditor cannot appropriate the things given by way of pledge or mortgage or dispose them. Any stipulation to the contrary is null and void. Familiar? Pactum commissorium. Di ba? Na-discuss natin yan last time pa. Yung pactum commissorium. The automatic appropriation by the creditor. Di ba? Na kung hindi makabayad si debtor, hindi niya pwedeng automatic na i-appropriate. Di ba? Hindi niya pwedeng automatic appropriate yung thing pledge para ibenta or saan na may-ari na pag hindi ka nakabayad creditor by this date, akin na tong ba? Hindi pwede yun. May process tayong pina-follow as provided by the law. Automatic appropriation is not allowed by law. It is illegal. So, as provided, right of creditor where debtor fails to comply with this obligation. So, pag-usapan natin yan dito. So, the property given in a pledge or mortgage stands as security, as we know, for the fulfillment of a principal obligation because it's an accessory obligation. So, the sale of the subject property, sana yan? The sale of subject property with formalities required by law. Yeah? Pag si debtor fails to comply with the obligation at the time it falls due, the creditor, take note, is merely entitled to move for the sale of the thing pledge or mortgage. Yan lang. With the formalities required by law in order to collect the amount of his claim from the proceeds of the sale. Diba? Sa mga auction yan. Diba? Sa mga judicial auction, extrajudicial auctions. Hindi yan pwede na, pag hindi ka nakabayad, automatic akin na yung property mo. No, hindi yan pwede gawin ni creditor. Kailangan follow yung process ng law. In this case, di ba? Sale of the thing in an auction, kung saan yung proceeds yan, i-apply sa utang. Yun yung gagamitin. Di ba? And ito, prohibition against appropriation of property, sa pactum commissorium natin, the creditor in a contract of real security like pledge and mortgage cannot appropriate to himself without foreclosure the thing held as pledge or under mortgage, nor can he dispose the same as owner. Because you're not the owner. The property is still the owner, the pledger is still the owner of that thing pledge. Hindi yan mababago. Oo. Kahit na hindi makabayad ng utang siya, si debtor, hindi yan automatic matatransfer yung ownership. May may proper process tayong i-follow, which is the sale of the property in an auction, kung saan yung proceeds doon, i-apply sa principal obligation, i-apply sa utang. Diba? Kaya, nor can he dispose the same as owner, the creditor. So, the prohibition applies to an immovable, which is the object of the contract of Antichresis. So, kahit sa Antichresis, na-apply yan. So, the act of the mortgage, for example, in registering the property mortgage in his name upon the mortgager's failure to redeem the property would amount to the exercise of the privilege of a mortgagee in a pactum commissorium. May exception tayo sa Article 2112. Pactum commissorium, automatic appropriation ng property na ginawang security bawal. Null and void yan. May exception tayo. Yeah? General rule, bawal. May exception tayo, Article 2112. Yeah? But take note, stipulation that contains pactum commissorium does not invalidate the entirety of the pledge or mortgage contract. It is only the stipulation that is void. The remaining part of the contract o pledge and mortgage is valid. Yung stipulation lang yung warak. Yeah? 2089, mahaba sa 2089. Yeah? So 2089, a pledge or mortgage is indivisible even though the debt may be divided among the successors in interest of the debtor or of the creditor. Therefore, the debtor's heir who has paid a part of the debt cannot ask for the proportionate extinguishment of the pledge or mortgage as long as the debt is not complete and satisfied. So take note, pledge, mortgage is indivisible as to the contracting parties. Indivisible yan. Whether that's joint or solidary, doesn't matter. It is indivisible. Diba? May example naman later on. Indivisible yan. So, hindi mo pwede sabihin na may example naman tayo later on. Basta yun. Neither can the creditor's heir who receive his share of the debt return the pledge or cancel the mortgage to the prejudice of the other heirs who have not been paid. Ngayon, from this provision is accepted the case in which, may exception tayo dyan, there being several things given in mortgage or pledge, each one of them guarantees only a determinate portion of the credit. Meaning, from that point nun, nag-appropriate na kayo na for this thing pledge, ito yung kanyang portion. For this thing pledge, ito yung kanyang portion na sinisecure. For this thing pledge, ito yung kanyang sinisecure. So, meaning there would be as many pledges or mortgages as there are things given in pledge or mortgage. So, in that case, pag na-satisfy na yung isang portion ng principal obligation, then that thing pledge or mortgage for that particular portion shall be extinguished na, shall be returned. Walang problema. Because you particularly appropriated, you particularly separated na itong bagay na ito, ipipledge natin for that portion, itong bagay na ito for that portion, itong bagay na ito, ipipledge or mortgage natin for that person. So, once that portion of the principal obligation has been satisfied, has been fulfilled, has been paid, then that particular pledge na inappropriate mo dyan, okay, will be returned. Walang problema. Because in that case, inappropriate mo. Ang sinasabi dito sa first three, wala kang ginawang appropriation. Okay. Understood. The debtor in this case shall have a right to the extinguishment of the pledge or mortgage as the portion of the debt for which thing is specially answerable is satisfied. So, kakonect niya dito is 2090. The indivisibility of a pledge or mortgage is not affected by the fact that the debtors are solidarily liable. So, that doesn't matter kung joint solidary. So, ito example natin. Yeah? A borrowed from B 20,000 pesos as to guarantee of payment. So, security yan. Security yan. Principal obligation yan. Ngayon, in order to secure that, that principal obligation, si A, pledge niya yung diamond ring niya worth 15,000 and a pair of earrings worth 5,000. To guarantee the payment or to guarantee the 20,000 principal obligation. Ngayon, si A pays 15,000 of the principal obligation. Though he cannot ask for the return of that ring, which is worth 15,000, because both the ring and the earrings are given to secure the payment of the entire obligation of 20K. Because the contract of pledge is indivisible. Diba? B may cause the sale of either or both of the payment of his credit. The same is true if A dies, leaving W and X as his heirs, and W pays 15,000 pesos. Ngayon, if the creditors are B and C and A pays B 15,000, B cannot return the ring to the prejudice of C who has not received his share. Yeah? The same is true if B is the only creditor and his dies, leaving Y and Z as his heirs and A pays 15,000. However, ito yung sasabi natin kanina. Yung ito. Yeah? If it was agreed that the ring was given to secure the payment of 15,000, yeah, for the 15,000 portion ng principal obligation, and yung earrings, the balance of 5,000, then A or his heirs pay 15,000, A can demand the return of the ring. Because in this case, ano nangyari? nag-apportion ka eh. Nag-appropriate ka na for this 15,000 portion of the pledge, yung ring. For this 5,000 portion of, for this 15,000 portion of the principal obligation, yung diamond ring. Yun yung sinisecure niya. For this 5,000 portion of the principal obligation, yung earrings naman ang pinipledge dyan. O pag nabayaran yung 15,000, okay, fulfilled na. Marireturn na yung diamond ring. Pag yung 5,000 na nabayaran, edi yung earrings. Ganon yun. Pag inappropriate nila. Dito kasi walang appropriation eh. Hindi sila inassign for this, for that. Dito kasi nagkaroon na ng assignment. Nagkakaroon na ng appropriation. Na this is for this is for that. Okay, once na fulfill yan, goods. Ito, A and B jointly liable to C in the sum of 20K. Secured by A's ring worth 15K and B's watch worth 5,000. So, pag binayaran ni A yung 15,000, he cannot demand the return of the ring even if the liability is only joint or proportionate because pledge is indivisible. Di ba? Indivisibility is not the same as solidarity. The former refers to the object of the prestation of the obligation, while solidarity refers to the legal tie of the obligation. So, pero kapag ina-portion nila yan, di ba, ina-portion nila yan, yung 15K, di ba, para dito, di ba, nag-pledge sila, okay, walang problema doon. Pero walang apportionment nangyari. Yeah. So, 2091, the contract of pledge or mortgage may secure all kinds of obligation, be they be pure or subject to suspensible conditions. Understandable naman. And lastly, for this chapter, a promise to constitute a pledge or mortgage gives rise only to personal action between the contracting parties without prejudice to the criminal responsibility incurred by him who defrauds another by offering in pledge or mortgage as unencumbered things which he knew were subject to some burden or by misrepresenting himself or to be the owner of the same. So, basically, sinasabi lang dito, the contract ko, pag nag-promise kayo na papasok kayo sa contract of pledge, ang mangyayari lang, di ba? Ang mangyayari lang, magkakaroon ng personal action. Ano meaning? Magkakaroon ng personal rights. Walang magkakaroong real rights. Di ba? Promise to enter into contract of pledge or the promise to constitute a contract of pledge or mortgage only gives rise to personal right that is binding between the parties. Ano meaning nun? Yeah? In that case, you can file an action to compel the other party to enter into a contract of pledge. Personal right yun. Wala pa kayong real right. Yeah? No real right in the property. Personal right lang. Anong purpose? To compel the other party to enter into the contract of pledge na pilitin nyo or enforce through the courts. Di ba? Na, nag-promise tayo na papasok tayo sa contract of pledge. Nag-promise tayo na papasok tayo sa contract of mortgage for this principal obligation. O, bakit pabebe ka? Ba't ayaw mo? Nagkaroon tayo ng kasunduan. So, in that case, you can go to the court, file an action to compel the other party. Okay. Personal right. Personal action. But, it does not create a real right on the property yet. Because promise pa lang yan eh. And criminal responsibility of pledge or mortgagor, etc., etc. So, let's go to chapter 2. Di ba? Pledge, but these are provisions that is applicable only to a contract of pledge. So, sa chapter 2 na tayo. So, Article 2093. So, in addition to the requisites prescribed in Article 2085, since pledge lang yung pinag-uusapan natin dito, di ba? Additional requisite for a contract of pledge is that it is necessary in order to constitute the contract of pledge that the thing pledged be placed in the possession of a creditor of a third person by common agreement. Bakit? Kasi nga, sabi natin, pledge is a real contract. So, for its perfection, it's record ang delivery. Yeah? Record ang delivery. So, an agreement to constitute the pledge only give rise to a personal action between the contracting parties. So, sir, in regard to that, anong klaseng delivery? Kasi we know there's two types, diba? Actual and constructive. Ngayon, either of the two, depending on the situation or the nature of the property or the nature of the contract. So, the validity of the pledge, yeah? Transfer possession is necessary or is essential to the validity of a contract of pledge. Ngayon, transfer of actual possession, diba? The delivery possession referred in 2093 means actual possession of the property, pledge, and a mere symbolic delivery may not be sufficient. So, sir, parang nakakaano eh. Kasi dito sabi, maybe. Yeah, maybe ang mere symbolic may not be sufficient. Pero dito sinasabi pwede ang constructive delivery. Take note of the wording. May not be sufficient. 'Di ba? Pagpuntahan niyo dito sa pangatlo, yeah? Anong sabi dito? Such delivery of the thing pledge may be sufficient to validate the pledge depending upon the peculiar nature of the thing. Ito sabi natin kanina, di ba? It depends. It depends on the nature of the thing. Kung pwede siyang actual possession or kahit yung constructive actual delivery or kahit constructive delivery, symbolic delivery, walang problema. Walang problema dyan. Example dito, symbolic or constructive delivery, di ba? Delivery of the key or the keys to the warehouse where the goods were stored. Kung saan yung goods na yun, yun yung magiging pledge. O instead na ita-transfer pa yung goods na yun, di ba? Magastos yun. Storage cost, transportation cost, di ba? Doon na lang sa warehouse. Para yun lang yung gastos. Yun yung expense. So, ang ibibigay na lang yung keys to the warehouse where the goods that is pledged is being stored. O, mas nakatipid pa kayo. O, that is constructive delivery. Walang problema. Whether that's actual delivery or constructive delivery as long as there's delivery. Yeah? And take note, yung class ng delivery depending on the nature of the thing that is pledged. So let's go to 2094. All movables which are within the commerce of men may be pledged, provided they are susceptible of possession. And kadikit niya, incorporeal rights, evidenced by negotiable instruments, bills of lading, shares of stocks, bonds, warehouse receipts, and similar documents may also be pledged. The instrument proving the right pledge shall be delivered to the creditor and if negotiable, must be endorsed. So ito sasabi natin kanina, di ba? Yung pledge pwede siya maging movable property, personal property, or documents that proves there's an incorporeal rights. Walang problema. Yan yung sasabi ni 2094 and 2095, yeah, personal properties. 2096, pledge shall not take effect against third persons if a description of the thing pledge and the date of the pledge do not appear in public instrument. Ito, na-mention ito kanina, di ba, sa distinction ng pledge and mortgage. Para maging valid against third person ang isang pledge, dapat it must appear in a public instrument. Yeah, pag-notarize nyo, ganun. Para maging valid siya against third person. Kasi if not, then it is only valid against the parties. Diba? 2097, with the consent of the pledgee, diba? Yung naka-receive ng kung kanino transfer yung object, yung thing, the pledge may be alienated by the pledger, kung sino yung may-ari ng thing, or owner, subject to the pledge. The ownership of the thing pledge is transmitted to the vendor or transferee as soon as the pledgee consents to the alienation, but the latter shall continue in possession. Diba? Ito yung sinasabi din kanina. Yung pledger, diba, sana may-ari niyan, sana nito toong ownership niyan, kaso lang, yung possession na kay pledgee. Ngayon, itong si pledger, gustong ibenta yan. Walang problema as long as may consent ni pledgee. Because of course, may right over that, may interest over that object si pledgee. Yan yung security niya eh. Para dun sa principal obligation, diba? So, may right over that si pledgee. So, kailangan ng consent ni pledgee para mabenta ni pledger yung property. Ngayon, once nabenta yan, yung possession na kay pledgee pa rin. Hindi yan mawawala. Because, in a contract of pledge, possession by the pledgee is necessary. Diba? And kahit na na-transfer na yan, diba? Transmitted to the vendee or transferee, that pledge, that thing that is pledged, subject pa rin sa contract of pledge, na kung saan, once hindi nakabayad si debtor, anong mangyayari? Okay. Kukunin niyang bagay na yan, ng na-pledge na yan, ibebenta, proceeds, bayad sa principal obligation. Yeah? So yan, basically sasabi 2097, okay lang, mabebenta yan ang contract of pledge, pero kailangan ng una, consent ni pledgee. Second, possession shall still remain with the pledgee. Because possession, ulitin natin, of the pledgee is necessary in a contract of pledge. 2098. 2098. The contract of pledge gives right to the creditor to retain the thing in his possession or in that of a third person to whom it has been delivered until the debt is paid because obviously it is a security. 29, security to the principal obligation. 2099, the creditor shall take care of the thing pledged with the diligence of a good father of a family. He has the right to the reimbursement of the expenses made for its preservation and is liable for its loss or deterioration in conformity to the provisions of this code. So, ano sasabi dito? Di ba, obviously, yung possession na kanino na kay pledgee. Di ba, na kay pledgee yung possession. So, ano mangyayari dyan? Yeah? Ano mangyayari dyan? O, kailangan niyang alagaan yan. Hindi niya pwedeng hayaang ma-deteriorate yan. And sometimes, or there are many times, na kung saan, para maalagaan yan, para ma-preserve yan, diba, para hindi ma-deteriorate, gagastos ka talaga. For example, kotse. Diba? Change oil. Diba? Palitan mo mga change oil, pagas mo, diba? Para ma-preserve yan. Kasi pag hindi mo yung gagawin, ma-deteriorate yan, masisira. So, yun, those are expenses for its preservation. Ngayon, in that case, don't worry. It's organic. Bakit? May right to reimbursement naman si pledgee. Siyempre, sino may-ari yan? Si pledgor. Alangan si pledgee ang gagastos dyan. Si pledgor yung may-ari. Diba? For his benefit naman yan, yung pag-preserve ng property. Okay, mari-reimburse. May right to reimbursement si pledgee. Sabi ni pledgee, oy, ito yung nagastos ko sa change oil, sa pagpapagas, bayaran mo ko reimbursement. Walang problema doon. And, in case or loss of deterioration of the thing pledged due to fortuitous event, diba, the pledgee cannot be held responsible. Bakit? Fortuitous event naman eh. But, in the case of, fraud, negligence, delay, or violation of terms of the contract, he shall be liable for the loss and deterioration. Yeah? Fortuitous event, walang kasalanan si pledgee. Hindi siya maging liable. Pero for fraud, delay, negligence, violation of terms of the contract pag nagkaroon loss of deterioration, the pledgee shall be liable. 2100. The pledgee cannot deposit a thing pledged with a third person unless there's stipulation authorizing him to do so. The pledgee is responsible for the acts of his agent or employees with respect to the thing pledged. So, di ba? Klarong-klaro naman sa 2100. Pwede yung i-deposit, pero dapat allowed siya. Pag hindi siya allowed, hindi pwede. 2101, the pledgor has the same responsibility as a bailor in comodatum in the case under Article 1951. Now, go to Article 1951. Di ba? Sa comodatum natin yan. Anong sinasabi sa 1951? It is basically talking about, di ba? Basahin natin. The bailor, Article 1951, the bailor who, knowing the flaws of the thing loan, does not advise the bailee of that same shall be liable to the latter for the damages which he may suffer by reason thereof. So in this case, kapag hindi in-inform ni pledgor si pledgee ng mga sira, ng mga flaws ng dating pledge, di, pag nag-suffer ng loss si pledgee because of that, the pledgor will be liable. Baka ba hindi niya din-disclose Di ba? Apply yan dito sa contract of pledge. 2002. If the pledge earns or produce fruits, income, dividends, or interest, the creditor shall compensate what he receives with those which are owing him. But if none are owing him, or insofar as the amount may exceed that which is due, he shall apply it to the principal. Unless there is stipulation to the contrary, the pledge shall extend to the interest and earnings of the right pledge. In the case of pledge of animals, their offspring shall pertain to the pledgor or owner of the animal's pledge, but shall be subject to the pledge if there's stipulation to the contrary. So, klarong-klaro naman dito, di ba? Gaya na sabi natin, same to sa deposit. The pledgee has no right to use the thing pledge or appropriate the fruits thereof without authority of the owner. Same to sa deposit. Yeah? Kasi ang lang dyan is right of possession Hindi naman right of usufruct. Hindi naman right of ownership. Right of possession lang. So, yung usufruct, the right to use, di ba? Hindi yan. Right of possession ka dyan meron. Pero, pagdating sa fruits, di ba? The pledgee can apply the fruits, income, dividends, or interest earned or produced by the thing pledge to the payment of interest if owing and thereafter to the principal of his credit. Yeah? Unless there's stipulation to the contrary, the interest and earnings of the right of pledge in case of animals, their offspring are included in the pledge. So, masasama yung mga anak ng animal na yan, ng mga animals. So, ito, example tayo, di ba? D borrowed from C. The debtor borrowed from the creditor, 1K. at 12% interest with certificates of stocks as security. So as we know, certificate of stocks, may dividends yan. So the interest is payable 6 months after the execution of the contract. So if the stock earned dividends, nag-declare yung board ng corporation, the same shall also be subject to the pledge if there's no stipulation to the contrary. Ngayon, si creditor can apply, shall apply such dividends to the interest. And if any, owing him after 6 months. If none is owing him up or insofar as the dividends may exceed the interest due, then yung excess na yon will be credited to the principal of 1,000 pesos when it matures. So, pwede nyo magamit. Pwede ma-appropriate dyan. Benefit naman yun talaga kay yung appropriate, beneficial naman kay debtor, yung ganyan Bakit? At least yung kanyang babayaran in the future, mas mabawasan. Because yung fruits niyan, ng ting pledge, yun ang gagamitin para pambayad sa portion ng principal obligation. So, that is beneficial to the debtor naman, di ba? So, 2003, unless the ting pledge is expropriated, the debtor continues to be the owner thereof. Expropriated, ano yan? Kunin ng government. Di ba? Ano yun? Inherent powers of the state. Ano ulit yun? Taxation. Police power. Eminent domain. Ano yung eminent domain? The power of the state to take private property for public use upon payment of just compensation. We call that expropriation. Expropriate yan. So, unless the thing pledge is expropriated, the debtor continues to be the owner thereof. Nevertheless, the creditor may bring actions which pertain to the owner of the thing pledge in order to recover it from or defend it against third person. Anong meaning yan? Anong meaning yan? For example, di ba, nagkaroon ng pledge. Ikaw, pledgee ka, nandiyan na sa'yo. Pledgee creditor ka. Nandiyan na sa'yo yung property in your possession. Now, doon sa third person, hinahabol yung property na yan. Sinasabi niya, ng third person na yan, ay, ako may-ari niyan. Ba't yan nandiyan sa'yo? Bigay niyo sa akin. So, nag-file siya ng action. In that case, kahit na hindi ikaw yung owner niyan, pledgee, kahit hindi ikaw yung owner niyan, di ba? You can protect it. You can bring an action for its protection as if you're the owner. Because you have right vested in that thing pledge. Yan sinasabi ni 28. So, may bring the actions which pertain to the owner. Meaning, kahit hindi ikaw yung owner niyan, pledgee, you can still bring an action to protect your right over it. Because you have right, you have interest in that thing pledge. As if you're the owner, yung pag-protect mo dyan. Kasi may interest ka over that. Yan sinasabi ni 2003. 2004, the creditor cannot choose the thing pledge without the authority of the owner, and if he should do so, or should misuse the thing in any other way, the owner may ask that it be judicially or extrajudicially deposited. When the preservation of the thing pledge requires its use, it must be used by the creditor but only for that purpose. So, ano sinasabi natin dito? As we have mentioned before, same rule sa deposit. Yeah? The contract of deposit. The pledgee who is in possession of the thing pledge has no right to make use of it. Walang right of use of rack dito kasi possession lang meron. Has no right to make use of it without permission from the owner. This is the same rule in deposit. It is in consequence of the fact that the pledger, in parting with this property, transmit only possession but not ownership, not the right of use of rack. So, yan yung rule dito. Ngayon, right of pledger to ask the thing pledge deposited. In the following cases, the owner may ask the thing pledge be deposited, diba? Judicially or extrajudicially. Bakit? Because of the certain cases na to, parang hindi na mapagkakatiwalaan si pledgee. Hindi na siya pagkakatiwalaan kasi because of the situation hindi na mapagkakatiwalaan si pledgee to still have possession over the property. So, in that case, ipapadeposit na lang judicially or extrajudicially. First, if the creditor uses the thing without authority. Di ba? The creditor, having the possession over the property, broke the trust. Bakit niya ginamit? Wala namang authority. Hindi naman binigyan ng authority para gamitin yan. Instead na kay creditor pa rin possession, since nawala ng tiwala, deposit na lang, judicial, extrajudicially. If he misuses the thing in any other way, similar reason, or if the thing is in danger of being lost or impaired because of the negligence or willful act of the pledgee. Same, di ba? Nawala yung tiwala to have the thing be still under their possession, pa-deposit na lang, judicially or extrajudicially. And take note, yeah, itong second part, when the preservation of the thing pledge requires its use, it must be used by the creditor but only for that purpose. Ano example natin? Same sa ginawa nating example sa deposit. Yung kotse. Yeah? Kailangan mo patakbuhin yan. Kundi masisira yan. Yeah? Kahit once a month, patakbuhin yan. Lalo na pag ano yan. Sensitive kasi yan eh. Pag natenga yan, di ba? Maraming kotse ang nasira nung pandemic, nung nag-start yung lockdown. Natenga sa bahay. Kasi hindi pinandar, hindi siguro knowledgeable yung may-ari, hinayaan lang matenga. O hindi nasikaso kasi umuwi ng probinsya, walang tao sa bahay. Diba? Ganun. So, maraming kotse ang natenga. So, ang sira, natenga kasi. So, in that case, yeah, as you know, knowledge na rin to sa inyo, kapag kahit na ano yan, hindi ginagamit ang kotse, kailangan nyo pa rin paandarin yan. Kahit at least once a week, once in 2 weeks. Diba? Paandarin nyo yan 15-20 minutes. Pa-circulate yung oils niyan, yung fluids. Diba? Para hindi masira. So, in that case, for each preservation of the car, patakbuhin mo. Preferably, diba? Patakbuhin lang, hindi lang basta buksan. Paandarin din. Yung vroom, vroom. Diba? Paandar nyo. Drive konti. Para hindi, for each preservation naman yan eh. So, 2005 tayo. 2105, I mean. The debtor cannot ask for the return of the thing pledged against the will of the creditor unless he has paid the debt and its interest with expense in a proper case. So obviously, because what? The pledge thing, the thing that is pledged is a security. So bakit yan isauli? Bakit niya i-demand yan for its return? Hindi niya pa nabayaran yung principal. Hindi niya pa na hindi niya pa nabayaran yung principal obligation. That thing pledged, common sense naman yan. 2106. If through the negligence or willful act of the pledgee, the thing pledged is in danger of being lost or impaired, the pledger may require that it be deposited with a third person. So, similar na sinabi natin kanina, di ba? The pledgee has the duty to preserve the thing pledged with the diligence of a good father of family. Ngayon, through his negligence or willful act, di ba? Masisira yung thing pledge, pwedeng ipa-require ni pledger na i-deposit yan sa third person. Di ba? Bakit, sir? It is for the protect. Siya pa rin yung may-ari niyan si pledger. Alangan. Kailangan niya iprotektahan yung pagmamay-ari niya. It is for his interest para protektahan yung pagmamay-ari niyan. Provided naman by the law. Yeah? Hinayang masira niya ni pledgee. So, alangan papanoorin lang ni pledger na nasira yung kanyang property. Of course, he needs to protect his right. 2107. If there are reasonable grounds to fear the destruction or impairment of thing pledge without the fault of the pledgee, the pledger may demand the return of the thing upon offering another thing in pledge, provided the latter is of the same kind as the former and not of inferior quality, and without prejudice to the right of the thing pledge, to the right of the pledgee under the provisions of the following article. The pledgee is bound to advise the pledger without delay of any danger to the thing pledge. So, ano sinasabi dito? The right of pledger to substitute the thing pledge. Yeah. Two remedies are actually granted by Article 2107. Which is the first one, to the pledger, the right to demand the return of the thing pledge upon offering a substitute. Yeah? Sabi niya, akin na muna yung kotse na yan. Ito na lang muna yung exchange ko dyan, di ba? You're offering another thing to be pledged. And yung second remedy, to the pledgee, the right to cause the same to be sold at a public sale, which is provided in 2108. Yan. So, talking about 2107 first, the following are the requisites for the application of 2107. Kung saan, the right to demand the pledger, the right to demand the return of the thing upon offering another na magiging thing of the pledge thing. So, the first requisite, the pledger has reasonable grounds to fear the destruction or impairment of the thing pledge. Di ba? So, kaya yung ginagawa for the protection of his rights. Siya para kasi may-ari niyan Di ba? Second, there is no fault on the part of the pledgee. So, dapat inosente si pledgee dito. Good faith. The third requisite is the pledger is offering in place of the thing another thing in pledge which is of the same kind and same quality as the former. Di ba? Kotse, BMW na kotse or another BMW. Same almost same kind, ganun. Or pickup truck, 2022 edition, pick up another pickup truck na 2020 edition rin. Same kind, same quality. And last requisite, the pledgee does not choose to exercise his right to cause the thing pledged to be sold at a public auction. This will go to, this will lead to 2108. Kasi dalawang scenario, dalawang remedy. Una, para kay pledger, na para return the thing and offer another thing. Kay pledgee, same scenario, same reason, kung siya yung mag-initiate, the right to cause the same to be sold at public sale. So, if without the fault of the pledgee, there is danger of destruction, impairment, or diminution involved with thing pledge, he may cause the same to be sold at public sale. The proceeds of the auction shall be the security, diba? Shall be a security for the principal obligation in the same manner as the thing originally pledged. So, klaro. Pag nagkaroon, di ba? Pure destruction, thing pledge without fault pledgee. Similar dito, scenario. So, dalawang option meron. Yeah? 2107 and 2108. Pero klarong-klaro, sa sinabi dito sa fourth requisite, the pledgee does not choose to exercise his right to cause the thing pledged to be sold at the public auction. Ano meaning yun? May superior right si pledgee pagdating dyan. Yeah? Kaya nandiyan requisite Di ba? Hindi pinili ni pledgee na ibenta yan sa public sale, public auction. So in that case, ma-apply mo sa 2107. Ma-apply ni pledger. However, kapag pareho sila, gusto ni pledger, return the thing, gusto ni pledgee, benta na sa public auction, sino yung mananaig? Pledgee, superior right. Kasi kung babasahin mo dito sa fourth requisite ng 2107, mangyayari lang to kapag hindi pinili ni pledgee yung 2108. Di ba? Klaro. 2009, if the creditor is deceived on the substance or quality of the thing pledge, he may either claim another thing in its stead or demand immediate payment of the principal obligation. So, klaro, the article grants two remedies to the pledgee in case he is deceived as to the substance or quality of the thing pledge. Sinabi na European car, yun pala, hindi pala European car. Diba? Low brand pala. O yun, thing pledge, deceive yun. To claim another thing pledge, ito yung mga remedies niya, to claim another thing in pledge, and to demand immediate payment of principal obligation. Parang hindi tamang paggamit ang and dito, di ba? Kasi dalawang remedies, either hihingi ka, dapat or yan. Palitan nyo to or. Kasi basahin mo yung article, he may either claim another thing or pledge, or, so dapat or to. Lagyan nyo lang or dito. So, either claim another thing in pledge or demand immediate payment of the principal obligation. Kasi klaro dito, the remedies are alternative. That is, his privilege to choose only one and not both. Article 2009 is of evident fairness to both parties. Diba? Bakit so, sir, may second option? Kasi tingnan mo, niloko siya. That trust was broken. Diba? Sinira yung pagtitiwala ni pledgee. So, in that case, since ayaw niya na, sinira mong trust ko sa'yo, okay, you may demand immediate payment of principal obligation. So, let's go to 2110. So, Article 2110 provides that if the thing pledge is returned by the pledgee to the pledger or owner, the pledge is extinguished. So, any stipulation to the contrary shall be considered to be void. So, if a subsequent, di ba, klaro naman, di ba? Anong contract of pledge? Anong purpose yan? Or anong nangyayari dyan? Delivery ng thing pledge kung saan natatransfer possession. Ngayon, the moment that the pledgee returned it to the pledger or the owner, kasi take note, pledger is the debtor, yung owner, pwede rin yung hindi si debtor mismo, but rather a third person. Di ba? Klaro yun. Kaya nga nakalagay ito, pledger or owner. Si pledger, si debtor yan. Yung owner, kaya sasabi or owner, kasi may mga times, di ba? Si third person, pwede siya yung mismo magpo-provide ng thing to be pledged. Kaya may owner yan dito. O kapag yun nangyari, si pledgee, sinauli niya kay pledger or kay third person that is the owner. The pledge is extinguished. Any stipulation to the contrary shall be void. Bakit? Kasi napakaklaro naman na because of this, diba? Because of this, the contract of pledge is already extinguished because the primary purpose, diba? The primary consideration is to have the thing pledged to act as a security to the principal obligation. So the moment that it is returned, the thing pledged is returned, there's no more contract of pledge. It is extinguished. Any stipulation to the contrary shall be considered to be void. Now, if subsequent to the perfection of the pledge, diba? After, diba? Contract of pledge na perfect na, subsequent to that, what will happen? The thing is in the possession of the pledger or owner. There's a prima facie presumption that the same has been returned by the pledgee. The same presumptions exist if the thing pledge is in the possession of a third person who has received it from the pledger or owner after the constitution of the pledge. Di ba? Ito, different scenario naman. Ba? Kaka-perfect lang ng contract of pledge. Later on, napansin na yung thing pledge is in the possession of the pledger na or the owner. So, anong masasabi mo dyan? Anong magiging marites mo dyan? Di ba? Anong i-assume mo dyan? Yeah, yun sabi nila. So, ang prima facie presumption is that si pledgee mismo yung nag-return yan. Si pledgee mismo. So, kung si pledgee mismo nag-return yan, then mapupunta kayo dito. Di ba? Pero take note, in this case kasi, di ba? Dito kasi presumption lang na nakita nyo na yung possession na kay pledger or owner na. Or na kay third person na kung saan nabigay kay third person through pledger or owner. Dito kasi hindi nakita na nagkaroon ng actual na actual na sinauli. Dito kasi may actual na sinauli o the pledge is returned by the pledgee. Klaro. Dito nakita lang na yung possession na kay pledger, na kay owner or nasa third person through pledger or owner. So since hindi dito nakita yung actual return, pero nakita lang yung possession, yung effect afterwards, ang mangyari lang is a prima facie presumption. Na kung saan, based on these facts, ito yung magiging conclusion mo. Di ba? Ganun yun. But take note, prima facie presumption lang yan. It can be proven otherwise by contrary evidence. Yun pala, through fraud, through machination, through panloloko, di ba? Nakuha, to thief, through stealing it, nakuha from the possession of the pledgee. Yeah, ganun. Kaya prima facie presumption. So don't confuse these two. Dito klaro ng return. There's an actual return. Since there's an actual return, contract of pledge extinguished, any stipulation to the contrary void. Dito hindi nakita na nagkaroon ng actual return. Ang nakita lang is yung possession na kay pledger na kay owner or nasa third person who has received it from the pledger owner after the constitutional pledge. So in this case, since hindi nakita yung actual return, kundi yung possession na lang afterwards, magkakaroon ng prima facie presumption that it was returned by the pledgee himself. But, take note, prima facie presumption lang yan. It can be rebutted by contrary evidence. 2111. Excuse me po. A statement in writing by the pledgee that he renounces or abandons the pledge is sufficient to extinguish the pledge. For this purpose, neither the acceptance by the pledger or owner nor the return of the pledge is necessary. The pledgee becoming a depository. So, dito klaro, di ba? Renounce. Renunciation. Abandon. Sabi ni pledgee. In writing. Statement in writing. I hereby denounce, abandons, this contract of pledge, etc., etc. So, in that case, okay, wala na. Extinguish na ang contract of pledge. Ngayon, if the possession is still with the pledgee, ano mangyayari? Hindi pa nasauli kasi hindi naman required ng acceptance si pledger owner, hindi naman required ang return para ma-extinguish kapag may statement in writing na. So, in that case, afterwards, if the possession is still with the pledgee, he will become a depositary. So, yung loss of on deposits na ma-apply natin dito. Yeah. 2112. The creditor to whom the credit has not been satisfied in due time. Di ba? Take note, ito yung exception natin sa yung isa sa mga provisions dito sa 2112 is an exception, the pactum commissorium. Di ba? Sinabi natin kanina. And this provides the process ng public sale natin. If in case hindi nakabayad, si debtor ng kanyang utang, so proceed sa pledge. So, the creditor to whom the credit has not been satisfied in due time may proceed before a notary public to the sale of the thing pledge. This sale shall be made at a public auction and with notification to the debtor and the owner of the thing. Kasi diba, debtor, the pledger, the owner of the thing, they can be a third person. of the thing pledged in a proper case, stating the amount of which the public sale is to be held. If at the first auction, the thing is not sold, a second one with the same formality shall be held. And if at the second auction, there's no sale either, nabenta, the creditor may appropriate the thing pledge. O yan na. Diba? Para siyang exception ng pactum commissorium. Kasi pactum commissorium, the creditor cannot automatically appropriate to himself the thing pledge. Diba? Pero dito sinasabi, daan muna sa public auction. Pag sa first one, hindi nabenta, okay, second one. Pag sa second one, hindi ulit nabenta, okay, the creditor may now appropriate the thing pledge. Pwede niya nang kunin yan. However, in this case, kapag inappropriate niya sa kanyang sarili, diba, sa akin, sige, yan na lang pambayad, akin na lang yan. In this case, he shall be obliged to give an acquittance of his entire claim. Na kung saan, whether the value of the pledge is more than, or less than, or equal to the principal obligation plus the interest, diba? Does not matter. Cancel or extinguish na yung principal obligation. Yeah? Right of pledge to cause sale of the thing pledge. One of the essential requisites of pledge is that the object pledge may be alienated for the payment to the creditor when the principal obligation becomes due. Yeah, so the formalities for such sale under the above article are as follows. Diba? The debt is due and unpaid. So, with that, proceed na. The sale must be at a public auction. There must be notice to the pledger and owner stating the amount due. Of course, kailangan silang inform. Diba? Ito mangyari. Diba? Bakit? Because they can bid sa public auction. Pwede sila magbigay ng bidding nila. Diba? Para mabawi pa nila yan. And the sale must be made with the intervention of a notary public. Notary public natin dito yung mga abogado, diba? Makita nyo yung notary public, diba? Sa mga law firms, may nakalagayan kung notary public sila. Kasi kailangan pa yung mag-register eh. Hindi yan basta-basta maging notary public kang isang lawyer, kailangan mo na mag-register yan. So, note that Article 1212 or 2112 does not require posting of the notice of sale and publication. Notification to the pledger and the owner of the thing pledge is sufficient. Yeah, because they have interest in that eh. So, they must be notified. And requisite yan, no? Only a notary public can conduct a public auction after notice is sent to the pledger and owner of the thing pledge. The sale is actually considered to be extrajudicial in character because there's no intervention of the court. Diba? Extrajudicial, outside of court yan. And, take note, right of pledgee to appropriating pledge. Diba? Ito yung sasabi ng exception to the pactum commissorium law o pactum commissorium concept or rule. The pledgee may appropriate the thing pledge if after the first and second auction, the thing is not sold. This is an exception to the prohibition against pactum commissorio. As we have paulit-ulitin sinasabi. Yeah? Ito yung kanyang exception. Yeah? First auction, di nabenta. Okay, second auction kayo. Second auction, di nabenta. Okay, in that case, pwede nang makuha yan ni creditor na yan na lang yung pambayad sa utang niya. Ngayon, take note, may rule dyan. May condition dyan. If the creditor appropriates the thing, it shall be considered as full payment for his entire claim. He is thus obliged to give acquittance for the same. The debtor is not entitled to the excess in case the value of thing pledge is more than the principal obligation. Yeah? Whether the value of the thing pledge, excess, kulang, or sakto lang, doesn't matter. Basta inappropriate na yan ni creditor, after the second auction walang bumili, principal obligation, boom, extinguish na. Article 2113. Kadikit niya si 2114. At a public auction, ito na, the pledger owner may bid. Kaya nga kailangan ng notice nila, di ba? Kasi they can bid because they have interest over the property. So, at a public auction, the pledger owner may bid. He shall moreover have a better right if he should offer the same terms as the highest bidder. So, pareho kung may highest bidder, di ba? Pareho sila highest bidder. 1 million, 1 million. Yeah? Same terms. Same offer. Sino mananaig? Si pledger o si owner. Yeah? Preference sila. The pledgee may also bid, but his offer shall not be valid if he is only the bidder. So, ito rin, pwede. Si pledgee, pwede siya magbid. O, ito, bayad ko. O, magbid siya. Pero kapag siya lang yung bidder dyan, edi invalid dyan. Yeah? Kasi parang naglolokohan lang kayo. Bakit? Kasi, alam niyo naman, di ba sa mga auction, yeah, pataasan yan sila ng price. Kung sino yung mataas, usually, edi yung matatanggap. Yan, napag-usapan natin yan yung discussion natin sa sale, yung sa auction. Yeah, usually, sino yung highest bidder, lalo na sa public edi yung So in this case, para hindi magkaroon ng dayaan, di ba? Baka bid-bid lang sila dyan para to pump the price up, di ba? Parang lolokohan, just to pump the price up, hindi pwede yun. So kaya yan may prohibition dito. Kapag siya lang yung bidder, yeah. 21.14, all bids at the public auction shall offer to pay the purchase price at once. If any other bid is accepted, the pledge is deemed to have been received the purchase price as far as the pledger or owner concerned. Dito sinasabi, okay, lump sum, cash ang bayad. Di ba? Ganyan sinasabi. Kapag nag-accept kayo ng bid, other bid is accepted, example, installment yung provide, yeah? As far as the pledger or owner concerned, yeah, the pledge is deemed to have been received the purchase price. Kahit na installment yung tinanggap nila sa public auction, pero para sa perspective ni pledger or owner, as if the purchase price has been received na. So, extinguish na yan. Diba? Wala na silang pake kung installment yan. Diba? Kasi sa installment, diba, medyo may risk pa dyan kasi may risk yang involved, diba? Credit risk, kung makakabayad o hindi. Diba? Kasi installment yan So, for the pledger owner, hindi na sila concerned dyan. Si pledge na ang bahala dyan. 21.15. Saan yan? 21.15. The sale of the thing pledged shall extinguish the principal obligation, whether or not the proceeds of the sale are equal to the amount of the principal obligation, interest and expenses in a proper case. If the price of the sale is more than said amount, the debtor shall not be entitled to the excess unless it is otherwise agreed. If the price of the sale is less, neither shall the creditor be entitled to recover the deficiency, notwithstanding any stipulation to the contrary. So dito, ang sinasabi ng 21.15 is yung scenario na kung saan, what if yung proceeds ng sale is more than the principal obligation with its interest and expenses? On the other hand, what if yung proceeds ng sale is less than the principal obligation together with interest and expenses? Ano yung magiging rule? Si 21.15 yung nag-provide niyan. The sale of the thing pledged extinguish the principal obligation whether the price of the sale is more or less than the amount. Diba? More or less than the amount. So, ano yung magiging rule? If the price of the sale sa public auction, yung proceeds, is more than the amount due to the creditor, yung principal obligation, interest and expenses, what will happen? The debtor is not entitled to the excess, hindi siya entitled sa sobra, unless the contrary is provided. So, pag walang stipulation na yung excess mapupunta kay debtor, hindi mapupunta sa kanya, kay creditor lang yan. Pero kapag may stipulation na yung excess ng proceeds ng sale is mapupunta kay debtor, hindi mapupunta sa kanya. Klarong usapan. Ngayon, pagdating sa second scenario, in the same way, if the price of the sale is less, di ba? Ang proceeds ng sale sa public auction, mas mababa compared sa ano yung due kay creditor. Di ba? Yung due kay creditor, 1.5 total. Pero yung proceeds ng sale is 1 million lang. O lugi si creditor ng 500k, kulang pang satisfy ng obligation niya. Ng obligation. Ano mangyayari? Neither is the creditor entitled to recover the deficiency. Any contrary stipulation is void. Dito, mas matindi yung nangyari dito. Ito kasi, debtor not entitled to the excess. Pero kung may provision na entitled siya, okay, goods, walang problema. Pero dito, yung deficiency, di ba, kay creditor, kulang Ito yung due sa kanya, 1.5, pero yung proceeds 1 million lang. So, may 500k deficiency. So, in this case, he is not entitled to recover the deficiency. Hindi niya pwede sabihin kay debtor niya, uy, kulang tong na-receive ko. 1 million lang na-receive ko 1.5 yung pagkakautang mo sa akin. Bayaran mo ako nung deficient na 500k. No, hindi pwede yun. He's not entitled. And any stipulation that provides for that is considered to be void. Di pwede. So, medyo harsh pagdating kay creditor. Kay debtor, pwede pa. Yung excess, okay. Yeah? Kung may stipulation naman, walang problema. Pero kaya Creditor in deficiency, wala. Any contrary stipulation is void. Bakit? The reason is to compel the creditor to hold an honest public sale. And second, kasi bakit? Baka kung gawin niyang malagyan ng stipulation ng deficiency, yung deficiency, obligado pa rin si debtor. O anong gagawin ni creditor diyan? Baka hayaan niya lang yan na kung ano man yung price diyan sa public auction, isipin niya kung deficient naman, babayaran man ni debtor, walang problema kahit magkano yan. O di ba? Hindi siya magiging diligent. O kaya ganyan, meron tayong prohibition kay creditor for him to be compelled to hold an honest public sale. Hindi siya magloko dyan. Maging diligent siya. Furthermore, the creditor should see to it, which he usually does, that he loans only as much as he's likely to realize at a public sale. So, yeah? And, meron pa yan dito Ito pa yung additional, Ito yung mga additional rationale in regards to that. In regards to these two rules. As a general rule, di ba, to the right of debtor to the excess, a general rule, therefore, the debtor is not entitled to the excess unless there's an agreement to the contrary. So, this is obviously to compensate the creditor for his risk of not being able to recover the deficiency in case the thing pledge is sold below the amount of the principal obligation. So, yung sinasabi. Diba? Generally, si creditor yung entitled sa excess unless there's stipulation na si debtor maka-receive yan. Why? In order to compensate for the risk na mabibear ni creditor, for example, yung proceeds ng sale is not enough to pay for the principal obligation, interest, and expenses that is due to the creditor. To compensate for that risk. Kaya may rule ganyan. This rule is nevertheless unfair since the obligation is fully satisfied. In effect, the rule would amount to a pacto commissorio which is prohibited. Under the Chattel mortgage law, which we'll discuss later on, the mortgagor is entitled to recover the excess of the proceeds of the sale in foreclosure. Ito naman, yung sa second rule, the right of a creditor to recover deficiency, kung saan wala naman siyang right, di ba? In the case of the creditor kasi, he is not entitled to recover the deficiency in all cases. Why? Why? Anong reason? By electing to sell the thing pledge, di ba? Instead of suing on the principal obligation itself, the creditor waives any other remedy and must abide by the rules of the sale. Na instead, di ba? By electing na ibenta na lang sa public auction yung thing pledge, he is, di ba? May risk dyan. He is entering into a risky situation. Risky transaction. Na baka, yung proceeds ng pagbenta sa thing pledge is not enough to cover the entire obligation. Diba? Pumapasok sa isang risky situation. Na kung saan, kung yung gagawin niyang option na lang is to sue the principal obligation itself. Diba? Yun na lang yung remedy niya. Yung diretso sa principal obligation instead of opting to sell the thing pledge in a public auction. Mas okay sana because the creditor may sue on the principal obligation instead of electing to sell the thing pledge, and in such case, he may recover the deficiency from the debtor. Diba? Mas sureball yung pag-sue sa principal obligation itself kasi mababawi mo lahat. Mas may chance, na mabawi mo lahat. Instead of electing directly to sell the thing pledge na kung saan medyo risky siya. Kasi baka hindi niya mabawi, 'di ba? Magkulang yung proceeds to cover the entire obligation. Yan yung sinasabi dito. Yan yung rationale ng dalawang to. Yung dalawang rules. 2116, after the public auction, the pledgee promptly advised the pledger honor the result thereof, of course, because they have the right. Yeah. Why? The purpose of this article is to enable the pledger or owner to take steps for the protection of his rights, where he has reasonable grounds to believe that the sale was not an honest one. So, kung hindi honest one, then you may file an action to protect their right, diba? Rescind, diba? Ganon. Rescission of the sale. So, 2117, any third person who has any right in or to the thing pledge may satisfy the principal obligation as soon as the latter becomes due and demandable. Paano yan? Yan to. As a general rule, the creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of obligation, di ba? Bawal yan. So, wala naman silang interest dyan. Pero dito, kapag may interest dyan, si third person, okay, pwede siya mag-interfere. Diba? Under this article kasi, 2117, a third person who has any right in or to the thing pledge as when the pledger has contracted to sell it to him, so may interest sa over the thing pledge, he may pay the debt as soon as it becomes due and demandable, and the creditor, take note, the creditor cannot refuse to accept the payment. Because in that case kasi, since may interest si third person over the thing pledge, diba may interest sa dyan, okay, pwede siya mag-interfere dyan. Yan yung sasabi 2117. 2118, if a credit which has been pledged becomes due before it is redeemed, the pledgee may collect and receive the amount due. He shall apply the same to the payment of his claim and deliver the surplus should there be any to the pledger. For example, di ba? Ang principal obligation, total due is 500k. Ngayon, ginawang pledge, thing pledge yung, let's say, accounts receivable or yung, let's say, accounts receivable, negotiable instrument. So, in that case, ano mangyayari? Nauna, maging due yung credit that is the thing pledge. So, let's say yung due ng principal obligation is February 28. Pero yung credit that has been pledged, yung due niya na babayaran is January 31. And since si creditor may hawak yan, si pledgee, yung may hawak ng document na yan, so sa kanya yung babayaran. He has the right to collect it. Ngayon, pag na-collect niya na yan, ano mangyayari? He will apply it to the principal obligation. Di ba? He will apply it to yung interest, expenses, yun sa principal amount na. Ngayon, kapag sumobra yan, may excess, di ba? Yung principal obligation, yung due lang is 500k. Pero yung credit is 600k. Yung thing pledge. O yung excess of 100k, he will deliver the surplus yung 100k kay pledger. Because 500k lang yung kanyang right over that. Yan yung sasabi ni 2118. Nothing too complicated. 2119, if two or more things are pledged, the pledgee may choose which he will cause to be sold unless there is stipulation to the contrary. He may demand the sale of only as many as the thing are necessary for the payment of the debt. So, klaro naman, 2120. If a third person secures an obligation by pledging his own movable property under the provisions of Article 2085, di ba? Balikan nyo, paulit-ulit tayo, di ba? Third person, pwede siya dyan, na siya yung ipipledge niya yung personal property niya. Di ba? Example, kaibigan niya si debtor para matulungan niya o pinledge siya yung kanyang personal property. So, he shall have the same rights as a guarantor under Articles 2066 to 2070 and Articles 2077 to 2081. So, magiging guarantor siya dyan. Is not prejudiced from any waiver of defense by the principal obligor. Magiging guarantor sa third person. 2021 and 2022, magkadikit sila. So, 2021-22, pinag-usapan dito yung, so far yung pinag-usapan kasi natin yung conventional pledge. Diba? The pledge that is through the agreement or stipulation of the parties. Dito sa 2021 and 2022, dito sa 21-21 and sa 21-22, ito na yung papasok na dito si legal pledge. Diba? Pledge created by operation of law, such as those referred in Articles 546, 1731, and 1994, are governed by the foregoing articles on the possession, care, and sale of the thing, as well as on the termination of the pledge. However, after the debt and expenses, the remainder of the price of the sale shall be delivered to the obligor. Kadikit niya, 2021-22, a thing under a pledge by operation of law may be sold only after demand of the amount for which the thing is retained. The public auction shall take place within 1 month after such demand. If without just ground, the creditor does not cause the public sale to be held within such period, the debtor may record the return of the thing. So, ito tatawag natin yung rules in case of pledge by operation of law. Ngayon, sa book nyo, you can just read ano yung mga instances na kung saan may legal pledge. Diba? Si 546, 731, and 1994. May pakilaman tayo dito yung kanyang rules when it comes to legal pledge. So, the first one. So, the provisions on the possession, care, diba? And the sale of the thing pledge as well as the extinguishment of the thing pledge governing conventional pledge are also applicable to pledges created by operation law. So, yung mga pinag-usapan natin kanina, mga rules, when it comes to pledge, di ba? Conventional pledge yun sila. Ma-apply rin sa mga pledge, sa mga legal pledge or sa pledge created by operation of law. However, may pagkakaiba lang. Ano yun? Provided dito, however, after the payment of the debt of the expenses, the remainder of the price of the sale shall be delivered to the obligor. Take note, yeah? Unlike, however, in conventional pledge where the debtor is not entitled to the excess unless it is otherwise agreed, pagdating sa legal pledge, pagdating sa pledge created by operation of law, yung excess, di ba? The remainder of the price of the sale after payment of debt expenses shall be delivered to the debtor. So, klaro, conventional pledge, generally, hindi entitled si debtor sa excess. Magiging entitled lang siya when there's stipulation for it. Yeah? Pagdating sa legal pledge, pagdating sa pledge created by operation of law, automatic yung excess delivered kay debtor. So, klaro, ulitin natin. Conventional pledge, generally, hindi entitled si debtor unless there's stipulation for it. Legal pledge, pledge created by operation of law, entitled sa excess si debtor. Matic. Ito sa number 2. The second rule, in legal pledge, there is no definite period for the, sinasabi dito sa 21-22. In legal pledge, there is no definite period for the payment of the principal obligation. The pledgee must therefore make a demand for the payment of the amount due him. Without such demand, he cannot exercise the right of sale at public auction. The pledgee must proceed with the sale within 1 month after demand. Otherwise, the debtor may require him to return the thing retained. So, last article sa chapter 2, 21-23, with regard to pawn shops and other establishments which are engaged in making loans secured by pledges, the special laws and regulations concerning them shall be observed, and subsidiarily the provisions of this title. So, the title referred to is Title 16 on pledges, mortgage, and Antichresis, covering articles 2085. So, parang supporting lang, complementary lang yung provisions of this title to those special laws that governs pawn shops and other establishments. Okay? So now let's go to chapter 3. Napag-usapan natin yung pledge, dito tayo sa mortgage, chapter 3. So, Article 21-24, only the following property may be the object of a contract of mortgage: immovables, and second one, alienable real rights in accordance with the laws imposed upon immovables. Nevertheless, movables may be the object of a chattel mortgage. Sir, movables, chattel mortgage. Paano yan? Take note lang, iba yung rules pagdating sa pledge, which are movables din, pagdating sa, as compared sa chattel mortgage, which are on immovables. Which are on movable. So, later on, madidiscuss natin yan si chattel mortgage. Yan yung last part. So, don't confuse it with pledge. Magkaiba si pledge, magkaiba si chattel mortgage. For now, pag-uusapan natin yung other mortgage o yung mas kilala natin. Diba? Ito yung mas familiar tayo. Yung real mortgage. Si real mortgage. Yan yung mas familiar tayo eh. So, definition of mortgage, diba? Otherwise known as real estate mortgage or REM, usually yan, or real mortgage. What is this? It is a contract whereby the debtor secures to the creditor the fulfillment of a principal obligation, especially subjecting to such security immovable property or real rights or over immovable property, which obligation shall be satisfied with the proceeds of the sale of said property or rights in case the said obligation is not complied with at the time stipulated. Because as we have said, di ba? Na-discuss natin kanina, di ba? Kinompare natin yung provision similar to pledge and mortgage, di ba? Security yan sila. Pag hindi nabayaran yung principal obligation, edi may remedy ka, nahabulin mo yung security na yan, nagamitin mo yung security na yan, benta mo, proceeds, apply sa principal obligation. Yan kasimple yan. But for now, pag-usapan natin is, ulitin natin, is real estate mortgage or real mortgage lang. So, as you have said din kanina, sa pledge, yeah, it is a real accessory and subsidiary contract. It is also unilateral because it creates only an obligation on the partner creditor who must free the property from the encumbrance once the litigation is fulfilled. So, cost or consideration of a mortgage, basahin niya lang, as a mortgage, it's an accessory contract. The consideration is that of the principal contract from which it is received, its life, and without which cannot exist as an independent contract. Sabi natin kanina sa pledge, similar lang dito. So, dito tayo ngayon sa kind of mortgage, mayroon tayong tatlo. Voluntary, legal, equitable. Voluntary, kung yun yung conventional, one which agreed to between the parties or constituted by the will of the owner of the property on which it is created. Legal naman, di ba? Created by law or to be executed in favor of certain persons, and yung equitable, one which, although it lacks the formalities or other requisites of a mortgage required by law, nevertheless reveals the intention of the parties to burden real property as a security for debt and contains nothing impossible or contrary to the law. So, but this equitable mortgage shall be governed by the articles in the Civil Code 1365, 1450, 1454, 1602, 1603, 1604, and 1607. Yan yung mag-govern sa equitable mortgage. So, ito subject matter of the mortgage. As you can see here, the object of a contract of mortgage are immovables and alienable rights imposed upon immovables. So, a real right over real property is a real property. Hence, a mortgage on real property is in itself a real property. So, paulit-ulit lang siya sabi dyan. So, the object of pledge and chattel mortgage, ulitin natin, are movables. So, 2125. So, in addition to the requisites stated in Article 2085, diba? Yung sabi natin kanina, yung sa similar provisions of pledge and mortgage, additional requisite for contract of mortgage, itong sa 2125. It is indispensable, in order that the mortgage may be validly constituted, that the document in which it appears be recorded in a register of property. If the instrument is not recorded, the mortgage is nevertheless binding between the parties. The person in whose favor the law established a mortgage have no other right than to demand the execution and the recording of the document in which the mortgage is formalized. So, klaro lang dito sa 2125. Take note lang, di ba? That it is indispensable in order that the mortgage may validly constituted that the person a public document duly recorded in the register of property. But, yan sabi natin last time pa, kahit na hindi siya recorded dyan, it is binding between the parties, kahit hindi siya na-register dyan. Ang mangyayari lang, it is not binding against the whole world. It is not binding against third person kapag hindi siya na-register sa registry of property. Yeah? Sa dito naman second paragraph, pinag-usapan dyan is right in case of legal mortgage. Diba? Kung saan, nasabi natin ito sa forms of contract which gives to the contracting parties the right to compel each other to observe the form required by law, like the execution of a document or other special forms, provided the contract between them is valid and enforceable. Talks about, diba? Pumasok kayo sa contract of mortgage. Wala kayong hindi nyo register. But you can demand the other, diba? Na i-follow yung proper format. Yan yung sinasabi pinag-usapan natin ito sa sa obligation and contracts, di ba? Kapag may certain formalities, di ba? Sometimes rarely lang kasi, as you have learned sa obligation contracts, rarely lang kasi yung mga instances na kung saan kapag hindi properly followed yung format, na magiging void yung contract. Example, donation. Yeah? Kailangan public instrument yun. Pag hindi yung public instrument, the donation is void. Ngayon, rarely lang yung mga ganong instances na kapag hindi na-follow yung format required by law, na magiging void yung contract. Usually kasi yung instances, kapag may format na nire-required yung law, ang mangyayari lang dyan kapag hindi na-follow is that it is not binding against third parties. Like this one. Yeah? Na kung saan, kahit hindi siya binding against third parties, it is still binding. Kahit hindi siya binding against third persons, it is still binding between the parties. Rarely lang magkakaroon ng instances, balikan yung obligon. Nandun na may examples, yung mga instances kung saan hindi na-follow yung format required by law, magiging void. Diba? Rarely lang ganun. Usually kasi kapag follow yung format, ang mangyayari lang, hindi siya binding against third persons, but it's still binding between the parties. 2126. The mortgage directly and immediately subjects the property upon which it is imposed, whoever the possessor may be, to the fulfillment of the obligation for whose security it was constituted. So, why? What are the effects of mortgage? Creates a real right. Diba? Article 2126 means, in other words, that a registered mortgage creates right in rem, a real right, alien inseparable from the property mortgage, which is enforceable against the whole world, affording specific security for the satisfaction of a debt. The personality of the owner is disregarded. Why? Because the right is imposed on the property itself. So, no matter who is the owner of that property, the right is there. Hindi magbabago. Because the right is on the property itself. Yeah? So, kahit saan may mapunta, kasi naman yung owner niyan, nandyan yan. And, creates merely an encumbrance. What is an encumbrance? Diba? It is a burden on the property, diba? Which provides some limitations on what you can do on that property. Yan yung encumbrance. Sabi natin last time. So, mortgage merely creates an encumbrance, a burden on the property which limits some of your actions na pwede mong gawin. So, a mortgage is merely a security for a debt, an encumbrance upon the property, and does not extinguish the title of the debtor who does not lose his principal attribute as the owner. Siya pa rin ang may-ari niyan, si debtor mortgagor. That is the right to dispose the property. So, indeed, the law considers void any stipulation forbidding the owner from alienating the immovable mortgage. Diba? Balikan nyo yung distinction ng mortgage and ng pledge na pinag-usapan natin kanina. Sa pledge, kailangan ng consent. Diba? Kailangan ng consent para mabenta yung property. Kailangan ng consent ni pledgor. Kailangan ng consent ni pledgee para mabenta ni pledgor yung property. Diba? Pero sa movable, sa mortgage, hindi kailangan ng consent. Diba? Discuss natin yan. So, kaya yung sasabi dito. 2127, pinag-usapan dito is what is the extent of the mortgage? Yung property lang ba? Hindi. Ma-extend pa yun sa iba. Sa ibang connected sa kanya. Yun yung sa 2127. The mortgage extends to the natural accessions, to the improvements, growing fruits, and the rents or incomes not yet received when the obligation becomes due, and to the amount of the indemnity granted or owing to the proprietor from the insurers of the property mortgage, or in virtue of expropriation for public use, with the declarations, amplifications, and limitations established by law, whether the estate remains in the possession of the mortgagor or it passes into the hands of a third person. So, yun lang sinasabi yan. Hindi lang sa property itself, but rather, yung mga connected sa kanya as provided here in 2127. Ngayon, in order to exclude them, it is necessary that there be an express stipulation to that effect. 2128. The mortgage credit may be alienated or assigned to a third person in whole or in part with the formalities required by law. So, ang problema, di ba? Mortgage credit, di ba, is the right of the credit of the mortgagee over that. So, yung mortgagee, di ba, sa kanya sinecure yung yung obligation. Yeah? So, yung mortgagee, sa creditor yan. So, yung mortgage credit, yan yung right ni mortgagee over the mortgage property. Ngayon, in that case, sabi ni 2128, he can alienate it. Pwede niyang i-assign to a third person. Walang problema. As long as the formalities required by law is followed. 2129, the creditor may claim from a third person in possession of the mortgage property the payment of the part of the credit secured by the property which said third person possesses, in the terms and with the formalities which the law established. Ang sinasabi dito, the mortgagor, as we have said, can transfer the ownership over the property. It does not matter when it regards to mortgage. Bakit? Because the real right is in the property itself. So, whoever, kung kahit sino maging owner niyan, walang problema. The real right is still there in the property. Walang problema. Nasa property lang. Hindi yan maalis dyan. So, kahit nabenta sa third person, it does not relieve the debtor from paying his obligation to the mortgagee creditor in the absence of obligation. So, the mortgage credit being a real right which follows the property, as I have said, the creditor may demand from any possessor the payment only on the part of the credit secured by said property. It is necessary, however, that prior demand for the payment must have been made on the debtor and the latter failed to pay. Sample naman tayo dito. Yeah? A mortgaged his land worth 500k in favor of B for what? To secure A's debt of 600,000. So, ngayon, later on, since mabenta naman ni A yung kanyang land, di ba? Walang problema doon. Any stipulation contrary to that is void, di ba? So, A then sold the land to C. So, in this case, the obligation of A to pay the debt is not affected by the transfer. Walang problema because the real right is over the property itself. Not on the person, but the property itself. So, on the due date of the obligation, B may demand payment from A, and if A fails to pay, B may foreclose the mortgage. B has the right to claim from C the payment of 500k, which is part of the credit secured by the property sold to C. C is not liable for any deficiency in the absence of a contrary stipulation. The spirit of the law is to let the obligation of the debtor to pay the debt and to stand all to the property mortgage to secure the payment of debt. Said debt, may have been transferred to a third person. So, the remedy of C, di ba? Wala sang choice eh. Hindi niya mahabol si B. Karapatan niya ni B eh. So, the remedy of C is to proceed against A. So, loko ka. Ganyan-ganyan. Yep. Kay A siya, mag-file ang action. 2130 stipulation forbidding the owner from alienating the immovable mortgage shall be void, as you have said. Yeah. And 2131, ito yung last article ng mortgage, pero mahaba yung discussion niya. So, 2131, the form, extent, and consequences of a mortgage, real mortgage both as to its constitution, modification, and extinguishment, and as to other matters not included in this chapter, shall be governed by the provisions of the mortgage law and of the land registration law. So, law governing mortgage, as to other matters not included in chapter 3 of the Civil Code, the land registration law, which is superseded by the property registration decree, and the revised administrative law, more particularly section 194, as amended by Act number 334. Don't worry, hindi yan kailangan nanin. Yeah? Govern the form, extent, and so its constitution, modification, and extinguishment. So, anong meaning ng foreclosure? Di ba? Pag-usapan ng foreclosure of mortgage. Di ba? Narinig nyo sa ano? Alam ko, familiar na kayo sa term na yan. Narinig nyo many times already. So, what is foreclosure? Diba? Hindi yun sa relationship nyo na kailangan nyo ng closure pag nag-break kayo. Diba? Iba yan. Foreclosure is the remedy available to the mortgagee, di ba, si creditor, by which he subjects the mortgage property to the satisfaction of the obligation to secure which the mortgage was given. Meaning, foreclose, benta, ano yung proceeds, apply sa principal obligation. Apply sa due. So, anong amount due? So, it presupposes something more than a mere demand to surrender possession of the object of the mortgage. It denotes what? The procedure adopted by the mortgagee to terminate the rights of the mortgagor in the property and includes the sale itself. Para yung procedure yan, i-apply sa utang. Ngayon, may dalawa tayong kinds of foreclosure. Judicially and extrajudicially. So, that is by ordinary action of the mortgagee or by foreclosure by the mortgagee under the power of sale contained in the mortgage. So, judicial action for the purpose. So, ito pag judicial foreclosure to. A mortgage may be foreclosed judicially by bringing an action for that purpose. Punta sa korte. In the proper court which has jurisdiction over the area wherein the real property involved or a portion thereof is situated. So, ganito na. Sa remedial law kasi, sa rules of court, di ba? May mangyayari yan na kung saan ka pwede mag-file ng action. Yeah, kung saan ka pwede. Kapag personal action yan, yeah, personal rights and personal action, pwede ka mag-file sa court na may jurisdiction kung saan ka nakatira, ikaw yung plaintiff, ikaw yung nag-file ng kaso, or sa court na kung saan may jurisdiction over kung saan nakatira yung defendant. Ganyan. So, kung saan ka nakatira, sino yung court na may jurisdiction dyan may file. Or, you can also choose or opt na mag-file sa court na kung saan nakatira yung defendant, kung sino may jurisdiction dyan, doon may file. Kung anong court na may jurisdiction doon. Ganyan pag personal rights, personal action. Kapag ganito, real action, real property nang involved, di ba yun? Kasi personal property. Pag ito, real property ang involved, mag-iiba ang usapan. Kung anong korte, yung may jurisdiction where the property is located. Sample, Zamboanga. O, kung anong RTC, di doon mo ipa-file. Di ba? Hindi pwede sa ibang lugar as opposed doon sa personal property. Hindi mo, kung saan si plaintiff, pwede doon. Kung saan si dependent, pwede doon. Pagdating sa real property like this one, real mortgage pinag-usapan natin. Kung saan situated yung property na yan, kung sinong court ang may jurisdiction dyan, dyan ka lang pwede mag-file. Klaro? Okay, klaro. Yeah? Kaya dito, wherein the property involved or a portion thereof is situated. So, if there's a balance due to the mortgagee after applying the proceeds of the sale ordered by the court, ito, take note, yung balance na to, yung excess, ano mangyayari? The mortgagee is entitled to, if there's a balance due to the mortgagee after applying the proceeds of the sale ordered by the court, ibig sabihin may deficiency, balance due to the mortgagee. Ibig sabihin, yung proceeds ng sale is not enough to cover the entire obligation. So, may deficiency. Anong pwede mangyari dyan? Diba? Sa usapan natin sa pledge, walang pwedeng bawian. Diba? Sa usapan natin sa conventional pledge, walang pwedeng bawian. Dito naman sa sa mortgage, real mortgage, tingnan nyo. Yeah? Pag may deficiency, tawag ito? Saan ako? Applying the process of sale ordered by the court, the mortgagee is entitled to recover the deficiency, and if this is invalid in the judgment, it is referred to as deficiency judgment. So, ito yung sasabi natin dito. Yeah? Pag may deficiency, ano yung usapan natin sa pledge? Kapag may deficiency, kulang yung proceeds to cover the entire obligation, si pledgee, wala siyang choice, di ba? Hindi niya mababawi, hindi niya ma-recover. It is what it is na yun. Pero pagdating dito sa mortgage, ibang usapan. Pwede pang mabawi ni mortgagee. Di ba? And kapag it is embodied in a judgment, deficiency judgment tawag natin doon. So, entitled si mortgagee. So, sa pledge, hindi entitled. Any stipulation pa nga is void, di ba? Pagdating dito, entitled si mortgagee. Where a third person is a mortgagor, he is not liable. Take note, di ba? Sabi rin natin, pagdating sa pledge and sa mortgage, pwedeng third person ang maglaan ng thing to be pledged or to be mortgaged na pag-usapan natin sa start pa lang. So, sa pledge, kahit third person, pwede siya maggawing thing pledge yung kanyang property. Similar din sa mortgage, pwede yan. Walang problema. Kaya dito na, where third person is a mortgagor, ibig sabihin, kahit hindi siya yung debtor, pero baka kaibigan niya si debtor, diba? Tinulungan niya, so ni-mortgage yung property niya, para matulungan niya kaibigan niya si debtor, diba? Walang problema. Allowed by law. Ngayon, where a third person is a mortgagor, is not liable for any deficiency in the absence of a contrary stipulation. The action for the recovery of such deficiency must be directed against the debtor. So, the proceeds of the sale, take note. Ito rin, the proceeds of the sale shall be applied to the payment of the following: the cost of the sale, the amount due to the mortgagee, claims of junior encumbrances or persons holding subsequent mortgages in the order of their priority, and if there's any balance, take note, if there's any balance, shall be paid to the mortgagor or his duly authorized agent or the persons entitled to it. So, ganon. Pag may deficiency, entitled si mortgagee maningil. Entitled si mortgagee maningil ng deficiency. Kapag may excess, entitled si mortgagor ma-receive yung excess ng proceeds over the amount due. Okay. Di ba? Pag din sa pledge, di ba? Conventional pledge, ano yung usapan? Hindi entitled sa excess si pledgor unless otherwise provided. Pagdating sa legal pledge, ano yung rule? Entitled si pledgor sa excess. Pagdating sa deficiency, si pledgee, wala siyang magagawa. Pagdating sa mortgage, pinag-usapan natin, kapag may deficiency, si mortgagee, entitled siyang maningil ng kulang. Diba? Entitled siyang maningil ng kulang. Now, yung proceeds, 1 million lang, pero yung amount due is 1.5. O pwede niyang singilin, si mortgagee, pwede niyang singilin yung deficiency of 500K. On the other hand, kapag excess naman, pagdating sa mortgage, entitled si mortgagor or his duly authorized representative to receive the excess. Yeah, di ba? Yung nila. So, dito naman tayo sa extrajudicial foreclosure. A mortgage may be foreclosed extrajudicially where where there is inserted in the contract a clause giving the mortgagee the power upon default of the debtor to foreclose the mortgage by an extrajudicial sale of the mortgage property. So, yan naman sa extrajudicial foreclosure. Now, lastly, pinag-usapan dito yung redemption in a foreclosed property. So, redemption may be defined as a transaction by which the mortgagor requires or buys back the property which may have passed from under the mortgage or divest the property of the lien which the mortgage may have created. In general, the concept of redemption is to allow the owner to repurchase or buy back. Kaya nga, redemption, di ba? Bawiin niya. Within a certain period or for a certain amount, a property that has been sold due to debt, tax, or encumbrance. So, it is allowed in cases of foreclosures in favor of banking and credit institutions and in extrajudicial foreclosure. So, redemption, due to the circumstances of the case, pwede mo mabawi, buyback. Yeah? Ngayon, kinds of redemption tayo under this foreclosure. So, equity redemption or the right of the mortgagor in case of judicial foreclosure to redeem the mortgage property after his default in the performance of the conditions of the mortgage. So, hindi nabayaran, so na judicially foreclosed yung property. Anong pwede niyang gawin? Before the confirmation of the sale of the mortgage property. Yeah? So, in this case, judicial foreclosure, pwede niya pang bawiin niya yung his equity of redemption as long as before but not after the sale is confirmed by the court. So, dapat before ma-confirm ng court yung judicial foreclosure, yung judicial sale, i-exercise niya na yung right niya for equity redemption. Before i-confirm ng court yung pagbenta sa property. Tandaan nyo, this is for judicial foreclosure. Ngayon naman, right of redemption or the right of the mortgagor in case of extrajudicial foreclosure. Ano naman mangyari dito? Anong namang rule dito? Di ba kasi dito, judicial foreclosure. Ito, extrajudicial. So, to redeem the mortgage property within a period from and after it was sold for the satisfaction of the mortgage debt. In all cases of extrajudicial sale, the mortgagor may redeem the property at any time within the term of 1 year from what? From the date of registration of the sale. So, 1 year. So, 1 year. So, dito, before but not after the confirmation of the sale by the court. Dito, 1 year from the date of registration. Extrajudicial foreclosure. So, in judicial foreclosure, the general rule is that the mortgagor cannot exercise his right of redemption after the sale is confirmed. Yeah? So, klaro yan. So, that is the discussion for real estate mortgage. So, now let's go to Antichresis, Chapter 4. I believe yung Antichresis, nabigay ko sa inyo yung general idea niya last time, di ba? Ngayon, ito yung discussion niya. Chapter 4, Antichresis. So, itong Antichresis, akala ko nung una, parang Antichrist ba yung pag-pronounce? So, Antichresis. So, dito tayo ngayon sa 2132. So, by the contract of Antichresis, the creditor acquires the right to receive the fruits of an immovable of his debtor, with the obligation to apply them to the payment of the interest, if owing and thereafter to the principal of his credit. So, napakaklaro kung ano tong Antichresis. Diba? As nabigyan ko naman kayo ng introduction ito last time, na kung saan si debtor may utang kay creditor. Now, in order to pay for that utang, na pag-usapan nila na mag-Antichresis na lang sila, in which na merong building and lot may building complex si debtor, na kung saan nag-ano siya renting business, nagpaparenta siya. So, with that said, ginawa nila, Antichresis sila, na kung saan yung proceeds ng rents from that building, yung fruits niyan, i-apply sa utang. So, that is Antichresis. That is Antichresis. Pero of course, may mga several rules na kailangan ma-follow. So, definition and characteristic of the contract of Antichresis. So, the above article defines the contract of Antichresis. So, it is an accessory contract because what? It secures the performance of a principal obligation. So, Manresa, however, believes that it is an independent contract. Sabi ko na last time, si Manresa isa yan sa mga tawag ito, sa mga commentators ng civil codes natin na kung saan may bearing yung kanilang comment. Pero yun usually yung ginagawa, may bearing yung kanilang comments, yung kanilang opinions. Pero para kay Manresa, independent contract daw siya. Pero para sa atin, it is an accessory contract. So, the formal contract, because it must be in a specified form to be valid. Example, it is in writing. So, Antichresis requires Article 2134 yan. So, Antichresis requires the delivery by the debtor. So, take note, sa real mortgage, immovable dun, di ba? Sa Antichresis, immovable rin. Pero sa real estate mortgage, hindi kailangan ng delivery. Hindi naman kasi need yun. Pagdating sa Antichresis, kailangan ng delivery. Antichresis requires the delivery by the debtor of the property given as a security to the creditor. But such delivery is required only in order that the creditor may receive the fruits and not the contract. And not that the contract shall be binding. Kasi yun naman ang purpose ng Antichresis Yung fruits ng immovable property, i-apply sa utang. So, paano makukuha ni creditor yung fruits na yan if wala siyang possession over the property? Diba? Para diretso sa kanya, i-apply niya sa utang. So, yan yung Antichresis natin. May delivery dapat, diba? Apartment complex. Okay. Bigay kay, hindi naman pwede actual delivery, diba? Kahit constructed delivery yan. So, in that case, okay, the possession, transferred kay creditor. Yung mga proceeds ng rentahan dyan, ng fruits ng apartment complex na yan, apply sa utang. Diretso kay creditor. Yan lang yung purpose yan. The contract does not cover the immovable but only its fruits. Kasi yung fruits ang i-apply sa utang. So, Antichresis and pledge compared. So, sa Antichresis, real property, pledge, personal property yan. Antichresis, perfected by mere consent. Ito, hindi ako dito Bakit? Puntahan mo yung mere consent, puntahan natin yung 2124. Disregard nyo tong number 2. Hindi ako agree dito. Char, parang no? Pero tingnan, malalaman nyo ba't hindi ako agree dito. Sa Antichresis, perfected by mere consent? No. Sa pledge, as we know, perfected by deliberating the pledge kasi real contract siya. Antichresis is a consensual contract, while pledge is a real contract. Consensual. Perfected by mere consent, consensual. Hindi rin agree dito. Malalaman natin later on bakit. While pledge is a real contract. Both are similar in debtor that loses control over the subject matter of the contract. Loses possession kasi bibigay kay creditor. Ito naman, Antichresis and real mortgage compared. Diba? Pareho silang immovable. Pero may difference sila. Sa Antichresis kasi, the property is delivered to the creditor. Kasi nga, kailangan makuha ni creditor yung fruits dyan kasi nga, i-apply niya yan sa obligation, sa principal obligation. Sa mortgage kasi, the debtor usually retains the possession of the property. Sa Antichresis, the creditor acquires only the right to receive the fruits of the property. Hence, it does not produce a real right. Fruits lang. While in mortgage, the creditor does not have any right to receive the fruits. But, mortgage creates a real right over the property which is enforceable against the whole world. Sa Antichresis, the creditor, unless there's stipulation to the contrary, is obliged to pay the taxes and charges upon the estate. While in mortgage, the creditor has no such obligation. Sa Antichresis, it is expressly stipulated that the creditor be given possession of the property and shall apply the fruits thereof to the payment of the interest if owing and thereafter to the principal of the credit. Sa mortgage, no such obligation on the part of the mortgagee. Yes, both of them, real property. Like pledge and mortgage, Antichresis gives a real right and not merely personal right if it is registered in the registry of property. So, let's go to 2133. So, 2133 talks about the valuation yan Valuation. Valuation of what? The actual market value of the fruits at the time of the application thereof of the interest and principal shall be the measure of such application. So, kung yung value ng ng fruits, din yung i-apply mo sa interest and principal. Yan ang sinasabi 2133. Ito yung 2134 natin. Check out this. The amount of the principal and of the interest shall be specified in writing. Otherwise, the contract of Antichresis shall be void. So, hindi yan perfected by mere consent because there's a formality required by law. Di ba? Agree kayo? Kayo bahala. Basta, that's my opinion. Ito kasi yung sa book Perfected by mere consent, consensual contract. Pero tingnan mo, kapag hindi mo finalo yan, magiging void yan. So, Antichresis is not perfected by mere consent. But rather, there's formality that needs to be done para maging valid siya. Kasi if you will not follow it, it is one of the rare instances where the formalities, when not followed, the contract shall considered to be void. Kasama ang antichresis doon, together with donation. Di ba? Together with donation of real property. Di ba? Kayo bahala. Pero yan yung sinasabi. Pero may point, di ba? So, saan yun? So, 2135, the creditor, unless there's stipulation to the contrary, is obliged to pay the taxes and charges upon the estate. So, he is also bound to bear the expenses necessary for its preservation and repair. The sum spent for the purposes stated in this article shall be deducted from the fruits. Ito yung sasabi natin ito. Diba? Obligations of the antichretic creditor. Antichretic creditor. Parang ano yung crustacean antichret. So, ito yung obligations niya. Diba? Kasi yung possession na transfer sa kanya, diba? Yung real estate, yung immovable property. So, the creditor acquires by the virtue of the contract of antichresis the right to enjoy the fruits of the property delivered to him. So, this right carries two obligations, which are this one. Diba? Paragraphs 1 and 2 of 2135, which are necessary consequences of the contract because they arise from its very nature. Diba? Payment of taxes and charges upon the estate. Diba? Real property tax, ganon. So, the creditor is obliged, unless there's stipulation to the contrary, to pay the taxes and charges upon the estate. Diba? If he does not pay the taxes, he is by law required to pay indemnity for damages to the debtor. So, yan, kailangan yung bayad. Nasa kanyang possession eh. Second, the application of the fruits of the estate. Another obligation of the creditor is to apply the fruits after receiving them to the interest if owing. And thereafter, pag nasatisfy ng interest, apply mo sa principal. In accordance with the provisions of Articles 2133 or 2138. So, the sum spent by the creditor in fulfillment of the obligation under the article shall be charged against the fruits of the property. So, no worries. Di ba? Bakit? Yes, the obligor, or the creditor, yes, babayaran niya to. Babayaran yan. Pero, yung nabayaran niya dyan, pwede niyang i-deduct sa fruits. I-deduct sa fruits. So, at the end of the day, kapag i-deduct niya sa fruits, mas less yung fruits na ma-apply sa payment ng interest, sa payment ng principal. So, in the end, in totality, walang binayaran si creditor. Di ba? Kung isipin mo. Kasi nga, the sum spent for the purposes stated in this article, madideduct niya sa fruits. Eh, ano ba yung purpose ng fruits? Di ba, yan yung ginagamit mo para i-apply mo sa interest. Pag na-apply na sa interest, nabayaran ng interest, sa principal naman. Yan yung ina-apply mo para mabayaran yung utang. So, if you will deduct it from the fruits, so, mas less yung i-apply mo sa utang. So, at the end of the day, parang si debtor din yung nagbayad niyan. Di ba? At the end of the day, wala nang binayaran si creditor. So, walang burden sa kanya. May burden sa kanya. Sa'yo magbabayad, of course, sa'yo mag-e-effort. Pero wala siyang ilalabas na pera because may reimburse na rin siya eh. Yeah? So, 2136, the debtor cannot reacquire the enjoyment of the immovable without first having totally paid what he owes the debtor. The creditor, But the latter, the creditor, in order to exempt himself from the obligation imposed upon him by the preceding article, itong payment na to, may always compel the debtor to enter again upon the enjoyment of the property except when there's stipulation to contrary. Ito, sa first paragraph, obvious naman eh. The antichresis, the immovable property, is a security. So, until hindi nababayaran yung security, yung principal obligation, the debtor has no right to compel the creditor to return the thing to him. Di ba? Kasi security yan pambayad ng utang. So, bakit mo kunin hindi pa bayad yung principal obligation? Di ba? Ngayon naman, si creditor may option siya. Kapag ayaw niyang siya yung mamblema nito, magbayad ng mga expenses na yan, he can compel the debtor to enter again, magamit ulit yung property para siya na yung magbayad nun, si debtor. Except when there's stipulation to the contrary. 2137. The creditor does not acquire the ownership of the real estate for non-payment of the debt within the period agreed upon. Obviously. So, every stipulation to the contrary shall be void. But the creditor may petition the court for the payment of the debt or the sale of the real property. In this case, the rules of court on the foreclosure of mortgage shall apply. Kasi ano yung sasabi ng yung first paragraph? Pactum commissorium yan, di ba? Pactum commissorium yan. So, hindi yan ma-appropriate sa kanya. Hindi yan walang automatic appropriation sa kanya pag hindi nakabayad si debtor na yung property ma-appropriate na sa kanya. Hindi. Every stipulation to the contrary shall be void because that is pactum commissorium. Ngayon, pag hindi nakabayad si debtor, di ba? Within the period agreed upon, may dalawang remedies na pwedeng gawin si creditor. First one, di ba? He may petition the court for the payment of the debt. Di ba? Bring an action for specific performance to compel, to force the debtor to pay his obligation. Yun yung first remedy niya. The second remedy is to sell the real property. Di ba? Foreclosure na of mortgage, foreclosure na. Di ba? Petition for the sale of real property as in a foreclosure of mortgage under Rule 68 of the Rules of Court. Yun. Di ba? The parties, however, may agree on extrajudicial foreclosure. So, yun yung dalawa. Bawal ang pactum commissorium. Tapos, dalawang remedies meron si creditor. Action for specific performance, bayaran ni debtor yung utang niya, or benta, foreclose yung property. 2138. So, the contracting parties may stipulate that the interest upon the debt be compensated with the fruits of the property, which is the object of the Antichresis, provided that if the value of the fruits should exceed the amount of interest allowed by the law against usury, the excess shall be applied to the principal. Take note, wala na tayong usury law dito. Indefinitely suspended yun siya. So, the last paragraph of Article 2085, Articles 2089 to 2091 are applicable to this contract of Antichresis. So, please see comments under 2085 and Articles 2089 to 2091, which are provisions on pledge and mortgage. So, ma-apply rin yan dito. So, that is a discussion for Antichresis. Now, let's go to the last part of our discussion, which is Chattel mortgage. So, Chattel mortgage, as you can see, diba? Dalawang ano lang siya. Dalawang articles lang siya. Pero medyo, no worries naman dito. So, at Chattel mortgage tayo, chapter 5. So, 2140 tayo. So, by a chattel mortgage, personal property is recorded in the chattel mortgage register as a security for the performance of an obligation. So, security ulit siya. Yeah? If the movable, instead of being recorded, is delivered to the creditor or third person, the contract is a pledge and not a chattel mortgage. Yeah? Pag dineliver, pledge yan. Pag hindi, chattel yan. So, chattel mortgage is a contract by virtue of which personal property is recorded in the chattel mortgage register to be considered as security for the performance of an obligation, and delivery is not necessary. Kasi pag may delivery yan, edi yan na ay isa ng pledge. So, characteristics ng isang chattel mortgage, di ba? Accessory contract siya because it is for the purpose of securing performance of principal obligation. It is a formal contract because its validity, registration sa chattel mortgage register is required. Necessary siya. It is indispensable. And it is considered to be unilateral. Bakit? It produces only obligations on the part of the creditor to free the thing from the encumbrance on fulfillment of the obligation. So, pag nasatisfy ng principal obligation, kailangan ng pakawalan yan ni creditor. So, chattel mortgage and pledge distinguish from each other. So, ito yung mga pagkakaiba nila. Yeah? In chattel mortgage, delivery is necessary. Diba? Kasi nga, it is a real obligation. Real contract siya. Sa chattel mortgage, baliktad natin. Sa chattel mortgage, delivery is not necessary. Sa pledge, delivery is necessary because pledge is a real contract. Chattel mortgage, registration of the same in the chattel mortgage register is required by law for its validity. Sa pledge naman, di ba sabi natin, i-register mo lang siya sa Registry of Property kapag gusto mo siyang gawing kapag gusto mong maging valid siya against third person. Diba? Kung hindi mo naman siya i-register, hindi siya public instrument, then it is still binding between the parties. Hindi siya required for its validity. Pagdating kasi sa chattel mortgage, for its validity, kailangan i-register siya sa chattel mortgage register. Diba? Sa pledge, hindi kailangan i-register. Kahit hindi siya nasa public instrument, it is still considered to be valid, binding between the parties. So, the procedure for the sale of thing as given is given a security is different. O, sa chattel mortgage, you will follow the procedure provided in Act 1508. Act 1508 is the chattel mortgage law. Sa pledge naman, kung ano yung sinabi ng Article 2112 ng Civil Code. Chattel mortgage, pag na-foreclose si property, the excess over the amount due goes to the debtor. Yes, goes to the debtor. Well, sa pledge, di ba? Kapag conventional pledge yan, the debtor is not entitled to the excess unless it is otherwise agreed, or kapag sa legal pledge na yan, entitled siya. So, tandaan nyo, chattel mortgage, debtor, entitled sa excess. Pagdating sa pledge, depende. Kung conventional pledge, hindi siya entitled unless otherwise stipulated. Kapag legal pledge, entitled siya sa excess, si debtor. So, ito naman, pag-usapan yung deficiency sa point of view ni to. So, in chattel mortgage, if the property is foreclosed and there's deficiency, the creditor is entitled to recover the deficiency from the debtor, except if the chattel mortgage is a security for the purchase of personal property in installment. So, in pledge kasi, ano yung usapan sa pledge? If there's deficiency, the creditor is not entitled to recover the deficiency notwithstanding any stipulation. Diba? Automatic, hindi entitled si creditor sa pledge for deficiency sa mortgage, entitled naman siya subject to this exception. So, ito naman, similarities naman between the two of them, ni chattel mortgage and ni pledge. So, both are executed to secure performance of a principal obligation. Diba? Next is that both are constituted only on personal property. Indivisible sila, constitutes a lien on the property kasi wala namang transfer of ownership yan lien lang, an interest over the property. In both cases, the creditor cannot appropriate the property to himself in payment of the debt, diba? Pactum commissorium. In both cases, when the debtor defaults, the property must be sold for the payment of the creditor. Yeah. And by both are extinguished by the fulfillment of the principal obligation or by the destruction of the property pledge or mortgage. So, yung similarity sila dalawa. So, let's go to 2141. The provisions of this code on pledge, insofar as they are not in conflict with the chattel mortgage law, shall be applicable to chattel mortgage. So, yung special law, mananaig, supplementary lang yung provisions ng civil code. Tandaan nyo, ha? General law kasi ang civil code as compared to special pag in this relatively. Kasi may special law in terms of chattel mortgage, so yun yung mananaig. Supplementary lang si 2141. Kung may conflict, edi mananaig yung special law. Alam niyo na yung rule na yun, di ba? So, laws governing chattel mortgage, di ba? The laws principally governing chattel mortgage are the following. Diba? Chattel mortgage law, Act number 1508 as amended. Civil code natin, as decided in this case, yung revised administrative code, revised penal code kapag nagkaroon ng violation, criminal act, and the ship mortgage decree of 1978. PD 1521 governs the mortgage of vessels of domestic ownership. So ito, paano na-involve ang revised penal code dito? Bakit nagkaroon ng criminal action? Ba't nagkaroon ng criminal action? Ito, offenses involving chattel mortgage. So, under the revised penal code, the following acts are punishable. Knowingly removing any personal property mortgage under the chattel mortgage law to any province or city other than the one in which it was located at the time of the execution of the mortgage without the written consent of the mortgagee. Kasi pag mag-register mo yung chattel mortgage na yan, kailangan kung saan yan situated, edi doon mo i-register. Isa yun sa mga basahin yung 1508. Maikli lang naman yung chattel mortgage law. Doon yun nandun. So, kung saan located, saan situated yung personal property, edi doon mo i-register. Ngayon, kapag imumove mo siya, di ba? Ililipat mo siya ng ibang lugar, knowingly, ibig sabihin with intention, and without the written consent of the mortgagee, then you will be in violation of the revised penal code. Second is selling or pledging personal property already mortgaged or any part thereof under the terms of the chattel mortgage law without the consent of the mortgagee, written on the back of the mortgage and duly recorded in the chattel mortgage. Ito, similar lang. Ito, dito naman, nagkaroon ng selling, nagkaroon ng pledging. Kung saan walang written consent ng mortgagee. So, violation din yan. So, subject matter of chattel mortgage, it must be always personal or movable property yan. Yeah? Always personal or movable property. So, creation of a chattel mortgage, paano yan? I believe it is in Section 5 o Section 5, Section 4 of Act 1508. The law as it now stands provides for only one way of executing a valid chattel mortgage. Ano yun? Diba? The registration of the personal property in the chattel mortgage register as a security for performance of an obligation. Diba? Diyan yung register for its validity. Now, under the chattel mortgage law, Act number 1508, if the property is situated in a different province from that which the mortgagor resides, the registration must be in both registers for it to be valid. Yeah? Otherwise, the chattel mortgage is void. So, it has been ruled that if the chattel mortgage is not recorded, it is nevertheless binding between the parties. So, puntahan nyo yung chattel mortgage law. Nasa Section 5. Nandoon yung yung form na kailangan para i-register. Ano yung form na kailangan yung i-fill up sa pag-register ng chattel mortgage? Nandoon yun. And isa doon yung affidavit of good faith. So, affidavit of good faith is an oath in a contract of chattel mortgage wherein the parties severally swear that the mortgage is made for the purpose of securing the obligation specified in the condition thereof and for other purposes, and that the same is a just and valid obligation and one not entered into for the purpose of fraud. So, nandoon yan. So, check nyo. Post nyo, punta kayo. Chattel mortgage law, Section 5, nandoon yung format. So, the chattel mortgage law in Section 5, in describing what shall be deemed sufficient to constitute as good chattel mortgage, includes the requirement of an affidavit of good faith appended to the mortgage and recorded therewith, but the absence of the affidavit vitiates a mortgage only as against third person without notice like creditors and subsequent encumbrances. So, ito naman pag i-foreclose mo na yung chattel mortgage kasi ba hindi nabayaran ni debtor yung kanyang pagkakautang. Di ba? So, after payment of debt or the performance of the conditions specified in a chattel mortgage, the mortgagee must discharge the mortgage in the manner provided by law. Otherwise, he may be held liable for damages by any person entitled to redeem the mortgage. So, pag nasatisfy naman yung condition, pag nasatisfy na yung obligation, okay, discharge mo na yung mortgage. Di ba? Ngayon, if the mortgagor defaults in the payment of the secured debt or otherwise fails to comply with the condition of the mortgage, ano mangyayari? The creditor has no right to appropriate to himself the personal property. Why? Pactum commissorium, di ba? Because he is permitted only to recover his credit from the proceeds, di ba? Foreclose mo yan, of the sale of the property at a public auction through the public officer in the manner prescribed in the Section 14 of the chattel mortgage law. So, ito. Pag-usapan dito yung right ni mortgagee to recover deficiency. Kasi sinabi natin kanina, or na-mention rin natin kanina deficiency, di ba? Kasi pag chattel mortgage, ano yung sa excess ni debtor? Ano yung mangyari sa excess? Entitled to si debtor. Pagdating sa pledge, ano yung usapan? Si conventional pledge, hindi entitled unless otherwise stated. Legal pledge, entitled to debtor's excess. Ito, additional discussion sa deficiency. So, ano mangyayari? Right of mortgagee to recover deficiency. So, where mortgage is foreclosed, the creditor may maintain an action for the deficiency although the chattel mortgage law is silent on this point. Why? Why? Because of the corollary obligation. What do you mean, sir? Dito kasi, yung excess entitled si debtor. Yeah. So, sabi ng discussion sa book, sa law book, because of that existence na entitled si debtor sa excess ng proceeds, it is just equitable, it is just proper through a corollary obligation that the creditor can also be entitled for any deficiency. Para quits lang sila. Kahit hindi stated sa batas mismo, but because of the existence na dapat quit sila proper, yeah? Okay. Silent kasi dun pagdating sa deficiency. Okay, sabi ng Supreme Court, yeah, corollary obligation naman, yeah, para just proper, entitled din sa deficiency si creditor. So, the creditor may maintain an action for the deficiency although the chattel mortgage law is silent on this point. Yeah, the reason is that a chattel mortgage is only given as security and not as payment for the debt in case of the failure payment. So the action may be brought within 10 years from the time the cause of action accrues, even if it's not a panalitan contract, because the obligation of the mortgagor to pay the deficiency is one created by law. And furthermore, the action is in the nature of mortgage action because its purpose is precisely to enforce the mortgage contract. So, etc. lang to, 10 years. Ba? Basta yung sasabi ko, since entitled si debtor sa excess, corollary obligation, it is just proper that the creditor is entitled to the deficiency. Where mortgage constituted as security for the purchase of personal property, payable installment. So, if the chattel mortgage is constituted, whether by the debtor vendee or third person, as security for the purchase of personal property, payable installment, no deficiency judgment can be asked, and any agreement to the contrary shall be void. Ito yung exception dyan sa deficiency. So, ano yung, di ba, pag-usapan ito sa sa real mortgage, ano yung application ng proceeds ng sale. Ito yung sa naman, sa chattel mortgage. Yeah, the proceeds of the sale are to be applied to the payment of the following. First, the cost and expenses of keeping the sale. Second is payment of the obligation secured by the mortgage, yung principal obligation. The third is claims of person holding subsequent mortgages in their order. And lastly, if there's any balance, it shall be paid to the mortgagor or person holding under him. Diba? Yung excess, bigay kay mortgagor, kay debtor. And lastly, the discussion on right of redemption. So, when a condition for the chattel mortgage is broken in the following may redeem. Yeah? The mortgagor, person holding subsequent mortgage or subsequent attaching credit. Huwag niya problemahin itong si person subsequent holding subsequent mortgage. Yeah? An attaching creditor who so redeems shall be subrogated to the rights of the mortgagee is entitled to foreclose the mortgage in the same manner that the mortgagee could foreclose it. The redemption is made by paying or delivering the mortgagee the amount due on such mortgage and the costs and expenses incurred by such breach of conditions before the sale thereof. So, upon the sale of personal property at a foreclosure or the execution of the sale, all rights of ownership leave the mortgagor, judgment debtor, and becomes vested in the purchaser. There is no right to redeem personal property. So, just don't worry too much about this. So, that is a discussion for chattel mortgage. So, that ends our discussion for credit transactions. Yeah? Ano yung una? Loan, deposit, guarantee, pledge, real estate mortgage, next, Antichresis, and ito, chattel mortgage. So that ends our discussion for credit transaction. So the next discussion would be next week, which would be on bouncing check law. Diba? Special law yun na ipapasok natin dito since may time pa. So with that said, if you have any questions, do not hesitate to message me on Teams. Okay, bye-bye. Love you.